Uh, we welcome you all to the awareness workshop on the Personal Data Protection Act number 9 of 2022. This is a combined workshop, workshop number 4 and 5. Given the introduction of today's session, given the success and the reception of the first 3 workshops under this series, in particular, the first general themed workshop, the 4th and 5th workshops will focus again on generic data protection themes. And given the time constraints, the 2 workshops will be combined and cover a broad range of topics. This combined workshop will bring together speakers both local and international addressing the impact of data protection regimes such as Personal Data Protection Act in general, with emphasis on specific areas as per the feedback received from participants. So this initiative was organized by Ceylon Chamber of Commerce in collaboration with Meta and ICTA, with a special thank to Ms. Sandhini Wickramasinghe, who has given us developing the concept notes and much valuable contribution towards this series. Today's workshop will primarily focus on the Data Protection Management Program, role of data governance in Personal Data Protection Act compliance, data protection impact assessments, cross-border data processing, data breach management under the Personal Data Protection Act number 9 of 2022, with reference to the regional and global trends. Let me introduce our eminent panel today. Mr. Mohan Chaturanga, Head of Data Protection and IT Governance, MAS Holdings. Mr. Darren Chang, Policy Lead, Singapore Personal Data Protection Commission. Ms. Lankesha Molligoda, Colombo Stock Exchange. And Mr. Jayant Fernando, General Counsel, ICTA. And Ms. Sandhini Wickramasinghe, Attorney at Law and Privacy Professional. With that, I'm sorry, I could not mention Dr. Ralph Saw from the EU Commission. With that, I would like to introduce our first speaker for today's session to begin the 4th and 5th combined workshop, Mr. Mohan Chaturanga, to start with the data governance in the context of personal data protection management and role of CDO. Thank you. Mr. Mohan Chaturanga, over to you. Mohan, are you there? Mohan, you can.
Yeah, sorry, my session got a bit disconnected. Thanks for that introduction, David. Thank you.
Okay.
Can you hear me? A quick screen check for me, if you can hear me.
Yes, we can hear you. It's clear.
Okay, sure, thanks. So we can have the slides on the screen, David, if possible, please. Right, thanks for that introduction. Thanks everyone for joining, and for today's discussion, we would like to, I would walk you through. I think there'll be other speakers who would give you perspective in different areas. So bit of data governance perspective around how we manage data, and bit of a larger ecosystem of data governance, an introduction to that, and then how we can connect that large ecosystem in terms of the privacy act that you have, the Data Protection Act, and how does that compliance and data act would get connected to a larger data governance structure where most organizations already follow, plus some of the organizations are planning to follow. So, and in a larger umbrella of data governance, the control frameworks, privacy and protection, how does that would come in? So if you can move on to the next one, I just wanted to give you a glimpse of that definition in the next slide, related to what that model looks like. So it's traditional to start with a definition. So I just want to put it out there. But to tell you that it's all about agreed upon models. So there is no right or wrong to this. So a governance framework around data is about setting up accountabilities and setting up decision-making criteria, setting up how are we going to understand certain processes. It's about setting up how are we going to execute it around the information that you have. So here there are multiple frameworks that people refer to. And based on the organization's appetite or other organization's objectives around data, this would differ. Why I say that, I'll give you a few examples. So a consumer-driven organization, so for an example, a telco or a banking sector organization, would look at data governance model in a way where it is pretty much driving into in terms of driving direct revenue, right? So trying to understand, which I will discuss later, in terms of how to monetize this data and how would you do predictive analysis around this. Whereas if you look at certain businesses who are in B2B space, so business to business services, so those organizations would rather look at it from a point of view, what kind of efficiencies would that bring to the internal organization? What kind of competitive advantage? What type of collaborations that B2B businesses can make by doing setting up data governance framework, so you're structured in a way that other people can seamlessly connect with you. So based on that objective, your model, your process, all that could change. But what I want to set context at the very beginning is that either way, you would have certain set of accountabilities, information flows, processes, and a model that the organization would agree, and then come into a conclusion in terms of how to do that. So moving on to the next, Devni, I think I wanted to give you the trends around data. So before we come into the whole discussion around Privacy and Data Protection Act connects, different organizations have logics around how they want. So there's four. Primarily, we are looking at four areas. So which gives a determination on how are we going to drive these initiatives. So one thing is organizations need to tactfully look into, see about what are your tactics, what are your strategies going to be used for all the data that you have. So if you look at an organization like a telco or a bank or a manufacturer, right now, with all the digital channels in play, you will have multiple points of data, structured, unstructured. What I meant by structured and unstructured is all the systems, emails, what is on your computers, on databases will be structured form of it. And then you'll have unstructured set of data, which is coming from all your social media integrations, all your visibility channels. So where you look into and where your some of other data sources may be. So what is your tactful way of doing it? So organizations look at that first. So then sometimes you go ahead and look in terms of cost of non-compliance. So if you look at regulated industries like telco to banking, there'll be a compliance requirement in terms of leaks, breaches, all that, where even the PDPA is going to be now a part of country's legislation. So whereas organization look at these multiple requirements, if you look at from a point of view where payment card industry, you have PCI DSS standard. So all this would come into play. And then as I mentioned at the beginning, that there are organizations who are planning to monetize data. So they want that data to earn money. So what's the right way of doing it? Looking at matrices, recommendations, selling raw data. So there are organizations who are doing it. So these are some of the other drivers, what you do with data. And then you are going to have data privacy as a leadership initiative now, which with countries legislations coming into play, and there's a lot of privacy concern that is coming around the globe. Now it has become a boardroom agenda. So how are we going to build that? Not purely from a point that's why you might see two different points, non-compliance and privacy separately. Why privacy separately? Some organizations look at it irrespective of whether you have to comply or not. When you are following data privacy practices, it builds credibility. So I'll give an example. So from an MAS point of view, so we set out in our data protection and privacy journey well before PDPS was in play. And even GDPR, it might not be directly relevant to us in a manufacturing space, but we wanted to build credibility and reputation around how we operate with our customers who are in EU to even in other regions of the world. So data privacy builds bit of credibility. So that brings so that there are some drive around that as well. So just wanted to lay out the objectives around this piece. Moving on to the other area. So organizations have different interventions, right? So we want to adapt certain regulatory landscapes, but organizations always need to not only look for one regulation, right? There'll be multiple regulations and pieces that you need to comply for. So PDPA will be one, and you have GDPR to other compliance standards that you want to, healthcare standards that you want to work with, payment card industry standards. But ultimately, it will be drilling down into few areas where, like, for an example, how can we demonstrate that there is a technical framework around this? And then the maintaining of records, what kind of categories out there? So what kind of data is processed? So these are the interventions that organizations are looking at in terms of the data layers that they have. So, and in terms of the design and configuration capabilities, so how this technology operates. So we might have, I'll give an example. So we might have data which is residing on multiple systems. You might have controls over one system, but not in another. Example, we create data lakes, data warehouses nowadays. So the source system, your ERP or HR system, might have certain controls how people access it. How are we going to replicate that going in terms to the data warehouse or the data lake, right? So how are we going to transform this? So these are some of the conversations that is happening. And I think we'll have a later conversation about DPIs, data protection impact assessments. What are the high risk technologies that you're using? What are the high risk practices that is within the organization? So these are risk assessments around it. And then we look into preventing breaches and what we call in our world in terms of the resilience against cyber breaches and security. So how fast can you respond? So when it comes to data security and all, we say it's not about gates, it's about breaks, right? So why we say that is you can't protect everything at a prevention layer. You might need to have a bit of resilience built over into the organization. So how individuals' data is handled, so that's going to be a different conversation as well. So I just want to set out some of the organizations' challenges and interventions that they're making in terms of regulatory compliance. So after that, I wanted to give you a bit of an overview in terms of, in the next slide, is what this whole data governance framework is going to look like, right? So what are the key components, right? So first of all, I think we need to set out the strategy. What are the control efficiencies? What are the growth and monetization examples? Okay, we run an app. Let's say we run a taxi app. What are we going to do with this data? How are we going to monetize this? How are we going to build channels with this data that our user experience is enhanced? There'll be a lot of applications that are coming in. So related to personal data, I'll give an example. You take a taxi app, and I'm going to track the individual's travel. So the whole objective is that we are going to give them an experience saying, if you have been to, I'll pick a Sri Lankan example. So if you have been to, let's say, one golf face 3 times a year, and all Tuesdays seems like September first week, Tuesday, you are going to visit one goal face. Are we going to prompt the user? Right? So you are going to use a lot of data points to analyze that based on the travel patterns. Example, if you are visiting, let's say, Golf Face Hotel, you are likely to visit one Golf Face as well based on your past data. So that's the monetization channel that you're going to build in terms of predicting your channels or rather predicting your travel. So there you are going to use a lot of data points. Now, how are we going to do that? So I'll come to that piece also later. So these kind of monetization frameworks that you build, that's one example. Even if you look at retail, online shopping, so you are going to do a lot of predictive analysis using cookies, the buying behaviors, buying patterns, just as you do even on social media on your likes and shares. So how are you going to do that? So when you'll have that overall data governance objective set up, then you're going to have certain elements where how are you going to now structure your data? So data lineage is about where that data is coming from. Then you are going to talk about the business glossary, what we call as, okay, what are these data fields, data elements that we are looking at? Then you are going to look at the data quality. So data quality is an important piece in terms of making that right or rather correct data on certain fields. So you might have garbage data coming in, which might later drive into a decision which is not useful. Then we have the privacy concerns. So then we have the access and security as well. So in Data Protection Act, you might see a lot of emphasis is taken on this area into almost all the areas, and how those personal data would be, protected in all these areas. And other thing is, then if you look at from a life cycle point of view, right? From an acquisition to processing, to analysis, to storage, sharing, retention, to purging. So in very layman's term, we call it data collection and data retention and data purging or destroying. So the three phases. But you widen this to the spectrum, you might see there are other middle steps that is out there. So all these layers, as I mentioned in a governance model, what will happen is who is accountable, what are the processes around this, what information is flowing from one place to another, what are the inventories of it. So this is how you create your data governance structure. Now let me emphasize. So usually in a corporate world, we take the data governance structure, not only looking at personal data, right? You look at the larger set of data and you build it. But then for each and every segment of data, there'll be a compliance requirement, right? So data privacy and data security requirement. I'll pick an example. So when you have personal data, now in data privacy requirement, data security requirement, there'll be PDPA requirements, personal data protection requirements coming into play. Even before that, if you look at data set of financial transactions, PCI DSS, the payment card industry security standard, will have requirements coming into play. Then if you're in healthcare sector and operating in outside country regions, you will have HIPAA controls coming into play. So when you have this architecture in place in an organization, you are going to place the compliance requirements into each block, right? So then you have the technology which is underlying and using data models, database applications, information delivery, integration capabilities. Because once you have all that, you need to set up technology which will map this. Example, I would say PDPA is asking you to pseudonymize data, right? So you should identify that under data privacy, under data security requirements. Then that get transferred into whether is it in the data processing or where is it in the data acquisition or throughout the life cycle, you need to do pseudonymization. Then in order to facilitate pseudonymization, do you have enough technology under your stack where in your data model or master data or data integration layers, do you have technology to support that? Otherwise, you won't be able to implement this throughout your life cycle of data governance framework. Example, I'll give a few more examples as well. Consent management. So at a data lineage point of view, okay, we are going to collect customers KYC here. Now, when you go to data acquisition, yes, in the collection field, how are we going to maintain that? Data minimization is going to be there, different technology is going to be there. In processing, likewise, how are we going to do that? And in the technology layer, you are going to realize, okay, I need a consent management tool to do this because I don't have a system to do that. Because if my customers are onboarding from a mobile app, so now you can basically download your mobile app and put an FD, right? So if your technology layer does not have that, because PDPA asks us to get the consent. So you can actually get the consent calling the customer, signing it on the paper. There might be, I think the team will explain on that. But if it's only technology driven in the data governance framework, you might need to understand these two poles and fix them in terms of technology. So this is kind of a wider spectrum in terms of how that is going to look like. So after that, I want to give you a bit of a view in terms of what these data sets are. So primarily, if you look at an organization, if in the next slide, you're going to see different types of data, right? So multiple types of data. This at a organization point of view, there'll be a lot of data that you're going to have in physical file format, physical archive format, electronic format, even some are internet based, of course, because it's not in your local systems. You are losing an integration or a web available SaaS platform, software as a service platform, and this data is there. How are you going to ensure that your controls that you're defining as an organization is going to be applicable there as well? And physical backups that you take, mobile devices that you take. So there are a lot of dynamics around it. So from a personal data point of view to employment data to financial account data, IT related personal data, from logging details to browsing history to IP addresses. So we are looking at a very large ocean of data. So that is where, so if you look at an organization, some of you may be connecting from banks to different kind of industries. So your data universe, defining that data universe and identifying the compliance requirements would be a good place to start, because you have the data governance model with, when you have the model with you, you would identify different data elements will have different kind of compliance requirement. What is there for transaction data under PCI DSS is different from what you are going to comply in PDPA. So I just want to give you a bit of a view in terms of how big this data element is going to be. So after that, I want to give you, once you come to this point in the next slide, what are the programs that you are going to run as good data governance controls. So usually, so from my experience, the next slide, Devni. So it's about strategy and roadmap. So what's your governance model? What's your operating model is going to look like? You might need to understand tools and technology charter. What are the tools and technology that you want to have? I think in different conversation, I can remember Mr. Jayant is also saying, so we have 24 to 36 months, but we have almost spent some months on it. You might not going to wake up someday and you're going to have a consent management tool. You're not going to have an encryption tool. You're not going to have a synonymization or masking tool. So you might need to plan it out, right, for the time being. So you have a gradual way of moving there. So that's why the inventory around how you manage metadata, where the data is coming from, the traceability and the lineage, how you interpret between this platform. And of course, next coming into the organization of it, you might need, so from my practical experience, so with a very large corporate around 16 countries with 70 plus business units, you need to have data champions coming in, an operating model with team structures, data stewards. There need to be, people at the ground. Example, your HR team will look after your employee data, whereas your sales team and marketing team need to look out for your consumer data. So you need to create champions and organization structure around this to handle it in terms of issues from data subject access rights, how we are going to manage. So sales team need to understand that as well, and have a training and development framework for them as well. And I won't dive into the privacy and protection area. You would have listened to that many times in other webinars as well. And in terms of the master data management, in terms of data architecture model, how are you going to scale? Is it a cloud platform? Is it on-premise platform? How are you going to manage this data is going to be important. And data quality management around what quality tools assessment, data quality implementations, because rules definitions is important. So data subject access rights, if you DSRs, if you get it under PDPA, is about the correction, the rectification of data, right? So if your data is incorrect, that the subjects will have the right to correct that. So would you have an internal process of doing it? So in terms of data lifecycle, at which point it will happen? So these are elements of these data that you will go through and see how it works. So as the last piece, in the next slide, I wanted to give you, before I wrap up on the introduction, it's not easy to give you a data governance framework in 20 minutes. But though I just wanted to give you a bit of a perspective around how this whole thing flows as a summary. So in terms of connecting specifically to privacy, so whereas you do an identification in terms of regulations, why you want to do this, different regulations, where you come from, and the policy, the standards towards shapes, data champions, the unit appoint a steering committee and all that, the policy around how that works. And then you move into the data capture phase. Where are you going to capture? So that is why I said at the data collection mechanism, you need to understand the minimization. So if you're if you are a healthcare provider and you are going to ask the tax number or TIN number or a tax, it doesn't make sense. If you are at a bank and you are going to ask a blood type, ain't gonna make sense. So minimize the data. You will be only able to minimize the data when you have that strategy of either monetizing or complying, or what are you going to do with data. So because in order to drive the business, you might need certain set of data, but if you are not using it, you might not need to be collecting it. So this is purpose driven. I think this is around purpose validation, about how you process, what are the principles of processing. So you need to have the valid principle of processing. So in order to do that, you need to stick to that process and minimize the data. So don't use it if you don't have a process for it. But if you have a process for it, because you might need to go back to the consumer and say, I'm going to use your location because I want to give you a predictive analysis when you come nearby that you can go here. So how are you going to convey that? So at an organization level, you might need to understand what that data monetization is going to look like. And of course, consent. So permission to opt in and opt out, and channel preferences. So how we implement during our GDPR implementations is that when we do channel representation, example, for marketing purposes, we might be connecting you through email. But whereas for anything else, for direct sales purposes or anything else of that sort, we might be calling you. So you want to have that purpose differentiation. So purpose differentiation and a channel preference over that. So for marketing purposes, only we have access to consent, or rather access to consumer to come and connect with us over the phone or rather email. But for anything else, for existing services that the customer is consuming us, we have the consent to call them. So how are you going to manage these two? When call center people start and sits there and want to make a call, do they know what channel do they want to make? So this is the consent management piece that you might need to think. And when you're operationalizing at storage and data usage, where these are going to be stored, data sensitive, the detection and discovery mechanisms. So there are tools of data discovery that you can run across your organizations and see what data is out there. You might need to do that because you might not know what data that you process as an organization, because it's not a one-stop go. What I meant by that is because you are not going to stop all your operations and then start PDPA compliant operation. It's your organization existing process and data sets that you're going to transfer to a compliant state. So you want to understand what is the existing data, right? So you have to do a discovery and see what are the data out there and classify and label those data. So this is personally identifiable data. So this database has personally identifiable, this is transaction data. And what, so if that is personally identifiable data, okay, what is the tag I'm going to put? Okay, we are going to put a tag saying PII. So there are tools to do that. So you might need to invest on those tools. So if that is PII, and under that, we are going to connect SPI, which is sensitive personally identifiable information. So we are going to mask and pseudonymize, or rather go for encryption and more technical controls over it. So likewise, you might need to do a discovery across the organization. And the most important piece is around the retention and purging, or how are you going to get rid of that data. So because you can't have data forever, and what's the time limitation? You, with your monetization mechanism, how are you going to connect that to the compliance framework and do it? So that's kind of like the structures. So I want to revert, and the one last point there I wanted to discuss is that whole life cycle your impact assessment would cover. So you want to understand from a data collection point of view to purging point of view, your impact assessment would highlight in terms of the impact and probability, what are the risks that you will occur. So your impact assessment is going to be a key component. Probably we'll have more discussion on that today. And that will be part of the larger framework where you will have more action in terms of operationalizing that. So that's the intro I wanted to give you in terms of data governance framework. Over to you, Temni, and I'm happy to take questions afterwards in the Q&A session.
Thank you, Mohan. With that, good insights, we would like to go to our second speaker. Then after the first session, we'll be taking Q&A before wrap up the first session. Let me invite for the second part of the first session, the framing a data protection management program and role of the DPO, local and regional perspectives. To share insights on this, I would like to invite Darren Chang to take over the session from here onwards.
Hi, good afternoon, everyone. I'm just going to share my slides. Okay, can you see anything yet?
Yeah, we can see your slides.
Okay, great. Thank you for attending the session, everyone. And I would like to thank the Ceylon Chamber of Commerce for inviting me to speak on framing a data protection management program. Time is a bit short. I think I still have 20 minutes, I think, but it's probably not enough to fit both topics in. So I'm just going to focus on DPMPs today. And before we start this segment, I just need to provide the standard disclaimer that for this workshop, I'm speaking in my personal capacity, and whatever I say should not be taken to represent my employer's views and does not constitute legal advice. All right. So Section 12(1) of your Personal Data Protection Act requires controllers to implement a data protection management program consisting internal controls and procedures for the purpose of complying with obligations relating to the processing of personal data in Part 1 of the Act. It's long, but what's helpful here really in subparagraphs 1A to 1H is that it gives you a skeleton as to what your DPMP is supposed to cover. And Section 12(2) says that the Data Protection Authority may issue guidelines in respect of the DPMP. I understand that your DPA has your authority, your Data Protection Authority has not yet been set up. So it may take a while for guidelines to be issued, but I think companies operating in Sri Lanka should definitely start planning what their DPMP should contain, what controls and procedures need to be put in place, because that and educating people about it, operationalizing it will take time. Like Sri Lanka, Singapore's data protection law, Like Sri Lanka's, Singapore's data protection law has an accountability obligation. And I think it's important, firstly, to understand what accountability means, because that will act as a guide in respect of what measures you should put in place for your DPMP. So very quickly, the concept of accountability focuses on whether the organization has taken measures to manage and protect personal data that it is handling in order to comply with data protection laws. And there are benefits to having strong accountability measures. You build a reputation for strong privacy management. You gain consumer trust and confidence in respect of your personal data handling practices, and you also meet the expectations of regulators. You know that under Section 12(1), you have to do things like have controls and procedures that provide for appropriate safeguards, that establish internal oversight mechanisms, but the devil is really in the details. So where do you start? And is there an easier way to get started? Well, in September 2021, last year, Singapore's Personal Data Protection Commission, where I work, published an updated guide to developing a data protection management program. And before coming on to this workshop, I searched around the internet for whether other jurisdictions had published their own guides and could not find anything. So right now we have one guide published by the Singapore Data Protection Authority, and why not have a look and see what we can use from it? So this is the cover page of the Singapore PDPC's guide to developing a data protection management program. It's 40 pages long, quite comprehensive and very helpful, I think. But it's pretty long, so I'm just going to go through the main points during this session. Now, the DPMP model in the guide comprises 4 components. First, you establish a governance structure to define values and identify risks with organizational leadership. Second, you develop a data protection policy and also practices. Third, you design processes to operationalize your policies. And lastly, you detail steps to keep your data protection policy and processes up to date. I'll go through all these 4 components one by one. So starting off with governance and risk assessment. Governance requires strategic direction, commitment, and a specific designation of responsibility for the management of personal data protection obligations. And in this respect, I think the 3 key figures in a governance structure are 1, the board of directors, 2, senior management, and 3, the DPO. This is important in relation to Section 12's requirement for controllers to establish internal oversight mechanisms. Starting with the board of directors would oversee and ensure the adequacy and effectiveness of the organization's risk management and internal controls in the context of the business and regulatory environment. Senior management is responsible for the organization's approach to handling personal data. This would include things like allocating resources, budget, manpower to data protection, appointing and empowering the DPO, providing strategic guidance on the implementation of data protection initiatives. And lastly, the DPO is responsible for ensuring that the organization complies with data protection laws. This would entail responsibilities like developing and implementing policy and procedures for handling personal data, advising management on personal data protection risks, managing queries and complaints from the public, and very importantly, developing training and awareness programs to educate employees on the organization's data protection obligations. When you have clarified who's in your governance structure and their roles and responsibilities, next you need to figure out how to identify and assess risks. There's a tool called the Data Protection Impact Assessment, DPIA for short, which will help you do that. And that is described in Section 24 of your Personal Data Protection Act. It's usually the DPO that conducts the DPIA. And if you need more information on DPIAs and what they should contain, Singapore's PDPC has also produced a guide to DPIAs. So if you're not sure about what exactly they are, what they should consist, you can do a Google search for the guide, or you can ask me for a link later on. Apart from this, organizations should also consider other risks, like risks affecting the achievement of the company's strategic objectives, affecting the company's operations, or compliance with other regulatory requirements. I think you should make sure you identify and document the personal data you handle, your personal data flows, the associated risks, as well as your assessment of the risks. For example, the level of risk, whether it's insignificant, low, medium, high, or critical, and the likelihood that the risk will eventuate. This sort of documentation will help you meet Section 12's requirement to design controls and procedures based on the structure, scale, volume, and sensitivity of processing activities. On to the second step, you will need to develop and communicate your policies and practices to internal stakeholders, for example, your staff, as well as external parties, for example, your customers and vendors. And this is important because doing so will provide clarity to your own employees and the vendors on their responsibilities in respect of personal data handling, and will demonstrate accountability to customers by informing them how your organization will protect personal data in its care. Examples of policies I think you need to look into drafting and having the privacy policy for employees. It is an internal document which tells your employees how to protect customer data. Another example is the privacy notice for customers to tell them how their personal data is used, how they can access their personal data and withdraw consent or make inquiries or lodge complaints. Requirements under Section 12 of the PDPA include mechanisms to receive complaints, conduct of inquiries, and processes to facilitate the exercise of data subjects' rights. For the third step, now that you have identified and assessed your risks, you need to make sure that they are addressed. So under the previous step, you would have already documented the personal data you handle and the data flows, as well as the risks associated with personal data and how personal data is being used. For under this step, now you would need to put in place controls and measures to address the risks. So Section 12 requires controllers to have controls and procedures which provide for appropriate safeguards based on your DPIAs. So for example, if through the DPIA, you identified that sensitive personal data is being stored in a server, then you may need to figure out what the right level of security protection is needed in respect of the server. Both physical and IT security. And then you also need to figure out what kind of security protection is needed in respect of the data sitting on the server in terms of, say, access controls and encryption while the data sits on the server. There will be, or there should be, residual risks, which are the risks that you cannot address, and you should make sure that these risks are monitored and reported on. So for example, the DPO should make sure that data incidents and remediation efforts are reported to the relevant oversight bodies to get their support, as well as direction and feedback. There should also be reporting from the working level to senior management as well as the board. So it's part of keeping the senior management and board aware of what's happening in respect of risks so that they can give strategic directions on how to address these risks. Moving on to the last component or step, there are a couple of things you need to do under this maintenance component. So you should perform regular review of your data protection policies and practices so that you can spot any new risks or gaps and address them. And also make sure that your policies and practices remain relevant. Section 12 requires the controller to ensure that your controls and procedures are updated based on periodic monitoring and assessments. There are also certain times when you should review your controls and processes immediately. Examples are major organizational changes, restructuring, or where a major incident has occurred. You need to find out if there were gaps that led to the incident. What should you do to make sure that your policies and practices remain relevant? You should monitor amendments to data protection laws in your country, as well as any sector-specific regulations, monitor any guidance or decisions issued by your data protection authority, learn about data breaches that have occurred in other organizations. For example, what caused the breach, how they remediated the breach, and try to make sure it doesn't happen in your own organization. Internally, I think you should also look out for new systems. When your project teams are designing new systems, when they're rolling out new systems, new projects involving the handling of personal data. For all of these items, I think it's important to get feedback from stakeholders. And the project teams working on these new systems, new projects to understand what's going on. And then you would analyze as well as analyze lastly any data incidents that occur. Oh, I think I managed to finish quite fast. Thank you. I hope this brings us back on time.
Thank you, Darren, for sharing your covering the area in sharing regional perspectives. Next, let me invite Ms. Lankesha Molligoda, Vice President, Regulatory Policy and Compliance, Colombo Stock Exchange. Lankesha, over to you to cover the framing the data protection management program and role of DPO in local perspectives.
Thanks, Devni. Let me try sharing the screen. If not, I'll let you know so that you can put up the slides for me.
Okay.
I think it may be easier if you could put up the slides for me. Is that okay?
Yes, sure, we can do.
Okay. Okay, if you could just enlarge it, that will be perfect. Okay, so good afternoon to all of you. So my task during the next 15 to 20 minutes is to help all of you in the audience to understand the critical sections in the Sri Lankan Data Protection Act, which you need to look at when you are framing your own data protection management program for your organization, and also about the data protection officer, the role and key considerations that you have to bear in mind when you do these two activities. So Darren also covered certain aspects of our act, and I think Mohan also touched on certain areas. So I will try not to repeat for the sake of time and take you through the Data Protection Act and the key provisions. Can we go to the next slide? Okay, so I think Darren covered this and gave you an idea also what a data protection management program is about. I myself is a compliance officer, so if there are compliance officers out there or IT personnel who is given the task now by the top management of the company to come up with a framework to ensure compliance with the local legislation, one thing I must start by saying is that it is not a difficult thing to do, because from my end, our company went through it and we have achieved a lot of success. So, and we have come very far. So these words may be big and this might seem complicated, but it's actually not. So I don't want to go into detail on this, what it is about, because Darren already covered this area. Devni, we can move on to the next slide. So I also found it very interesting, the Singapore Commission, the guidelines they have published in the absence of Data Protection Authority in Sri Lanka. So of course, when we were implementing and going on our compliance journey, we also considered the EU GDPR, which were both very useful. So for you today, I selected the 4-step approach that has been set down by the Singapore Commission, but I don't want to repeat it because all 4 steps were taken through by Darren. So these are the main things that you should largely look at when you're framing your program. So in the interest of time, I will skip this slide as well, Devni. Okay, so let's just get into this. I think before we actually go into thinking of having a data protection management program for the organization, I think we all need to understand why we need to have it, so that when we understand the fundamentals better, we really know how to get to our objective. So basically, if you have a very good data protection management program, it will help your organization to demonstrate accountability in data protection. I think that is a fundamental, it's a key thing for any organization, and it would provide confidence to your stakeholders, and it will enhance, of course, consumer trust, and it will give you a competitive advantage over your competitors. And basically, it will also be like a guide to your data protection officer and also your other data champions who you have entrusted the task, the company has entrusted the task of data protection. They will have a solid framework to follow. So that is basically why every company to whom the local legislation on data protection is applicable should consider having a very good, solid data protection management program. Next slide, Devni. Okay, so we can move on to the first section. Right. So the key provision is section 12, which we have to focus on. Section 12 only sets out the duty of every controller to implement internal controls and procedures. This is the main section which Darren took and gave you international perspective, rather regional perspective, a comparison with the Singapore guideline. So, although the data protection management program is referred to in the section, what we need to understand it is this section is basically talking about implementing internal controls and procedures which are sufficient for the company to demonstrate compliance with the Act. Although there are so many items A to H here, it is not complicated. I think all of you can go through it. And basically they are talking about how you have to comply with sections 5 to 11. Those are the critical sections in the Act which talks about the conditions for data processing by a controller and a processor. So I will go through those, I think those sections in detail rather than spending time on section 12 because Darren also touched on it. Devni, if we could go to the next slide. Yes. So section 6.1, subsection 1 talks about the obligation to define a purpose for personal data processing. So every controller that is processing data should actually process it for a specified, explicit and legitimate purpose, right? And if you are further processing this data, it can't be in any manner incompatible with your primary purpose of collection. Then if you go to section 7 of the Act says it has to obligation to confine personal data processing to a defined purpose. So the purpose has to be adequate, relevant and proportionate. I think Mohan brought up certain very valid points from his experience at his organization. You don't collect information that is not necessary for your purpose. So main thing that you need to do when you are framing your framework is to start with a data classification to understand what sort of data does your organization collect for this particular purpose based on maybe goods or services you're providing or whatever the sector or business you are in, and then understand, are you taking excess? If so, you should then reconsider what you are collecting and classify your data, and that would be the starting point for your establishing your framework. Next slide, Devni. Okay. So section 8, obligation to ensure accuracy. So every controller has to ensure that personal data that is being processed has to be accurate and kept up to date, and they have to take every reasonable step to erase or rectify any inaccurate or outdated personal data without any undue delay. So section 9 also speaks of the obligation of a controller to limit the period of retention. So that means whatever the data that you collect, you can't keep it forever if you are not providing that particular service to your consumer or your customer. So you have to ensure when the relationship or the ties sever, you keep it only if it is necessary in terms of the Act, or if not, you erase or destroy your data according to your framework that you have framed. Next slide. Okay, so section 10 talks about the obligation to maintain integrity and confidentiality. I think this is a key component which Mohan also spoke about in detail. So every controller has to ensure integrity, confidentiality of the personal data that they are processing, and they have to use appropriate technical and organizational measures or access controls or such other appropriate measures to comply with this obligation. So that's why when you frame your data protection management program, you have to make sure that you incorporate the necessary tools to comply with this particular obligation, whether it may be encryption, pseudonymization, or anonymization. So all these factors have to be considered what is most suitable for your organization, depending on the extent that you are processing the information and the information that you are processing. Section 11 is also important. The obligation to process personal data in a transparent manner. So under this section, a control has to provide data subjects the information that the Act speaks of in Schedule 5, and any information on any decision taken pursuant to a request made under the Part 2 of this Act, which is the data subject's rights. And these have to be provided either in electronic or electronic form, in concise, transparent, and easily accessible form. So these are some of the key provisions that you have to consider, each compliance officer or the IT team of the company or the legal officials, when you are framing your own data protection framework in your organization. So this is one aspect regarding the program. So in the program, so there has to be someone to run the program. So that is where the data protection officer comes into place. So in the next slide, we will speak about the role of the data protection officer according to what is set out in the Act. So before going into the role, I'd like to highlight Section 20 of the Act, which speaks about the appointment of the data protection officer. And because the Act in particular says that the controller or the processor has to designate or appoint the DPO to ensure compliance with the PDPA in certain circumstances, right? So there are two, A and B, which sets out certain instances where each company has to appoint mandatorily. So of course you would see here that certain yardsticks will have to be prescribed. In Section 20A, subsection B, if you look at in all Roman 1, 2, 3, they use, the Act uses the word as may be prescribed. So we have to wait and see when the Data Protection Authority puts out, that when the regulations under the Act comes, but these regulations would be. So we will be able to get a better understanding. But however, this section, even as it is now, gives us a good understanding whether our organization would need a data protection officer and whether we would have to designate a person to comply with this provision. Next slide, please. Okay, so same section goes on to explain about who should be this data protection officer. So the company has to consider certain things before appointing the data protection officer. So obviously the data protection officer has to possess relevant academic and professional qualification, and that person, he or she, has to have suitable academic background, knowledge, and the technical skills. So depending on the size of the organization and the extent of the magnitude of the data that you are processing, you will have to very wisely select the data protection officer considering all these things. So then it goes on in subsections 3 and 3 to say, if you are a group of companies, how you can have a single data protection officer. This is a good thing from a compliance perspective. I think the Act also has taken into consideration the compliance costs that will have to be borne by the regulatees. And also the main important thing is, once you appoint the data protection officer under your framework, you have to make the details known. Who is this data protection officer and how can someone reach out to this data protection officer? Maybe your consumers, other stakeholders, suppliers. So if there is a data breach or even a data subject, if they want to exercise their data rights under the Act, they should know who they have to reach out to as the DPO. So the best approach would be to have all these details up in your website. Next slide, please. Okay, so this is the role of the data protection officer, section 20, subsection 5. So the data protection officer has to advise the controller and the processor of how the company should comply with the PDPA and any other applicable laws. So obviously, if you are in the banking sector, you would have your own banking laws, secrecy laws to comply with. So also, and you have to do capacity building of the staff involved in the data processing operations. You have to provide advice on personal data protection impact assessments, and also you have to cooperate and comply with any directives and instructions issued by the authority in the future. So this is basically the role expected from a data protection officer under the Act. Okay, so having gone through the provisions which I thought I should share with you, which you should consider when you are building your framework within your organization, I would like to share our experience, our journey from our organization, this CSE. So what I have to say here is that we started our journey long time ago, very voluntarily, because we collect a lot of data on a daily basis, trade information, which extends from a name to contact details to NIC passport numbers to bank account details, so on and so forth. So we have a lot of personal information of all our investors with us. So we started our journey, and we in our phase 1, so we build our framework on our ISO certification 27001 2013, this ISMS version. So this is how we build our framework, but that doesn't necessarily mean that you need to build it that way. So this is how we started our journey. So large organizations who have the capacity could look at this. Otherwise, you could build your own framework to meet the Data Protection Act requirements. So then this is back in 2013, we started our journey. And as phase 2, when 2017-18, when the GDPR came into, was implemented, then when we analyzed our situation, us providing services to EU citizens in terms of investment. So we had to comply with the EU GDPR and take necessary measures to come up to to comply with the EU GDPR and the regulations they have issued thereunder. So we started our journey by mainly conducting a gap assessment. So where we are and where should we be in terms of the GDPR. So we had some external assistance where we hired experts. So we conducted a gap analysis where we started by identifying and classifying our data. As I told, that is the starting point in my in my experience. And we did a gap assessment, and then we understood exactly where we are and how we fall short and where we need to go. So then we understood that we need to have and enhance our policies and procedures. So we enhanced our data protection policies and brought in certain privacy policies. Also, we brought in the data subject request response procedures, because the GDPR also speaks about, similarly to the data protection Sri Lankan Act, of the data subjects' rights. So how we should respond to their requests. And then, of course, the breach notification procedures in case of a breach of our obligations. And also we had to do some amendments to our ISMS policies and procedures to elevate the framework to meet GDPR compliance. Next slide. In the next slide, so even our journey, of course, we are still going. So the phase 2, we appointed for the GDPR, we have appointed a suitably qualified data protection officer who could handle the role and responsibilities that is stipulated under the GDPR. And also we strengthened our internal controls in line with the ISO 27001. I don't intend to go into detail. So this is how we decided to comply with the GDPR. and comply with the obligations that we have under that. So in our compliance journey is still ongoing with the Sri Lankan Act coming into implementation. So, but we were told that after a gap, I mean, we are currently going through a gap analysis also from the GDPR to the Sri Lankan data protection legislation, but we are told that we are not far away from achieving the local standards, where we might need only a little bit of tweaking. So any company out there in the audience who are already GDPR compliant can be very satisfied that you don't have much things to do to comply. So you will have only a little bit of tweakings here and there to comply with the local legislation if you're already compliant with the GDPR. And also you all can also look at this getting the implementing the new extension for ISO 27001, which is ISO 27701, which our organization is looking at currently to enhance our data protection framework. So all in all, this has been our journey. But in the next slide, Devni, please. So I would like to just tell you what the key ingredients are. I think Mohan also touched on this. Like, it is not a very mechanical, technical thing to do, because when you are establishing a data protection framework, a management program, it is vital that you have the buy-in of your own board and the senior management, because if there is no commitment at the top level, it is very difficult to implement this at an organization level. So it has to be embedded to your own governance structure there, then only it will be very successful. So as compliance officers, if you're out there, so you have to, it is vital that we have a thorough understanding of the requirements. Then only you will know where you currently stand and what you are required to do to achieve compliance. Then it is also through my experience in implementing it at the exchange. So we understood that it is a collaboration amongst so many teams that you can't, no one can do it alone, because depending on the magnitude of data that you are processing, it will be a big task. So depending on the size of your company, so you may need your legal people in, your IT people in, your compliance people in, everyone driving together and going towards this goal. And also it is not only at the top you need the commitment, but you have to develop a workplace, a culture of accountability for data protection, where each employee who is processing data will understand their responsibility and their commitment towards this goal. So it has to be from a top to bottom approach, where you have to make every employee understand their significance in this process. So that is why you need to train your staff towards data protection, give them adequate awareness and alert them of their responsibility. And once you come to a position where you are compliant, I think the journey cannot stop there. As our previous speaker said, it is a continuous reviewing and upgrading program. It is it's a continuous evolution. So you have to evolve, because I think the data protection laws will also evolve, and so we have to be ready to evolve with it. So I think that is what I wanted to tell you from a local perspective, share our experiences from exchange perspective. So I hope you were able to get some kind of an understanding about the provisions that you need to look at in the Act, and hopefully you can build your own framework very successfully. Thank you. Over to you, Devni.
Thank you, Lankesha, for the informative overview of under the framing data protection management program and role of DPO. With that, I would like to go to the next item of today's program, which is the panel discussion of the first session. I would like to introduce our moderator, Ms. Sandhini Wickramasinghe, attorney at law and privacy professional and a member of Data Protection Law Drafting Committee, to moderate the session and take the session forward. Sandhini, over to you.
Yeah, thanks, Shahara. So I'd like to thank the speakers earlier who shared their thoughts, initial thoughts on data governance, data protection management program, and also on the DPO. So I'd like to invite back Lankisha Monligodin, who is the Vice President, Regulatory Policy and Compliance at the Colombo Stock Exchange, and Mohan Chaturanga, who is a General Manager leading IT and Governance and Data Protection Officer at MAS, and also Darren Cheng, who's a technology lawyer working at the Singapore Personal Data Protection Commission as a policy lead for global cross-border data flows, data transfer mechanisms, and children's data. So I'd like to invite the audience also to keep their questions coming on the Q&A and on the chat. So just to get the conversation going, I'd like to direct this question to all three panelists because, I mean, most of the conversation we've had, you know, sort of intersect with each other. So my question is, what would be your advice to controllers who are just starting off their compliance journey under the PDPA? And what would, I mean, where would you advise them as the ideal place to start? Because we do have some time left for the PDPA to come into full force and effect, but should we wait until the last minute, or, I mean, what's the ideal place to start of this whole thing? So maybe perhaps I could start with Lankisha.
Yeah, Sandhini. So I think we all touched on this aspect a little bit, I think, in our speeches as well before. Yes, we don't have the authority in place yet, and we don't have the maybe the regulations and the guidelines in place. But I think we have the act now, you know, which is quite detailed, where every organization can gather quite a lot from the act, what is expected. So I think organizations should not wait till the end because in our experience from our organization, it was not a quick journey. It was quite it took time, you know, to understand the requirements and internalize it, because each organization is unique in its own nature. It will process unique information, so it is not across the board same where you could copy someone else's framework. So each organization, the compliance team, legal team, IT team, they would also have to understand where they fit in the act. What sort of data they are dealing with, classify and understand, because as I think Mohan said in his presentation, that the treatment is different of different type of data. You will have to comply with different standards. So I think we have enough to start with. So you should start now. That is my advice to controllers who are yet waiting to start the journey. So for those who have already started the journey and have come somewhere, I think is in a good position. So I would invite everyone to whom the act is applicable to join hands and to join the bandwagon immediately, because it would be helpful at your end, because you would have ample time to frame a good framework in response to your legal responsibilities under the PDPA.
Thanks, Lankisha. Perhaps Darren would like to add some thoughts on this matter?
Yeah, sure. Okay, the lawyer in me says start by reading the Personal Data Protection Act and figure out what you have to do. But I know people here are business owners with no legal background. So I think if you're reading it, you might go like, oh my goodness, there's so many things to do. Where do I even start? Which is what your question is. And so I think actually a great place to start is really what I mentioned just now, the Data Protection Management Program, because when you have a framework, like if you refer to the PDPC's guide, it takes you through the things you need to think about, and it gives you steps as to what you need to do. So early on, I talked about the 4 steps or components that would take you through to creating a data protection management program. It would take you through what you need to do to create that, as well as build up your own compliance program. So I think for business owners, start from that. It will help you think about what kind of governance structure you need to put in place, and will also help you delegate jobs, roles and responsibilities to people so that you don't have to do it all yourself.
Thanks, Darren. Mohan, any additional thoughts you may like to add?
Yeah, Sandhya, can you clarify the question for me? I just lost my connection a bit, came in late. Sorry.
Yeah, so the question was, what would be your advice for the audience today as to the ideal place to start their compliance journey under the PDPA? I mean, if you were to give one simple advice, what would that be?
Yeah. So I think first is to understand what you want to comply for. So it is to understand what your applicability is. So are you having personal data? So do you process personal data? Do you collect personal data? So I think the answer does not lie outside. The answer lies within the organization. So you need to look into yourself and understand, are you processing personal data? And why do you process that? And that would be the first step. So without doing anything else, no investment further required. First, to understand the applicability. What is the extent of the applicability and the scope of applicability? That is the first point I think the organizations need to understand. Everything else is secondary. And I think even that is where we even started. Scoping out applicability and identifying your exposure is number one.
Thanks, Mahan. I'd like to elaborate a bit more on this role of DPO, because I think that's one of the key concerns of controllers and processors in Sri Lanka at this point. So I'd like to revert to Darren on this point. And because how can, in your opinion, how can a DPO ensure that the organization conforms to a comprehensive and a sustainable data protection management program? And is there any special emphasis given in the PDPC's DPMP guidance in this regard?
Okay, you've asked a really tough question, I think, and I spent a while thinking about this because there are a few parts to it. So when you're talking about comprehensive and sustainable DPMP, I'm not really sure I have an answer to that, because I don't know of any organization that can confidently say that its DPMP is comprehensive and sustainable. Maybe only MNCs that have been in existence for a while and that had put in place a DPMP a long time ago may be able to say that. Otherwise, carrying out a DPMP, I think, is not a one-person job, and it's very important for the board, senior management and the DPO to be on the same page in relation to the organization's vision and goals in respect of personal data protection, and for the DPO to also receive support from them and adequate resources to put in place the controls and processes required by the DPMP.
So based on your experience, what kind of position or authority should a DPO have within an organization so that it will help him to effectively discharge his statutory obligations?
There are many different structures out there, and just going back to what I think we should or companies should first do, I think something that's very important is to first check if there are any requirements under the law in relation to the DPO. So, for example, is there a requirement that the DPO be independent, meaning that they should be exercising the functions independently and should not be taking on any other roles or tasks that may result in a conflict of interest with their role as a DPO. This is what the GDPR requires under Article 38.3, and Thailand's data protection law expressly says that the DPO can perform other duties or tasks which do not conflict with the performance of the DPO's duties set out under their law. So this is very explicit in Thailand's data protection law. And in comparison, again, Singapore does not have such a requirement. So the other aspect that I think companies need to think about and look at the law in relation to is whether there's any requirement as to who the DPO should report to. So for example, the EU GDPR says that the DPO must directly report to the highest management level. and this can refer to the CEO or board of directors. Again, Singapore has no such requirements. So if your PDPA and your regulations are silent on independence and reporting line, then you have more freedom in terms of organizational structure. And in Singapore, many companies have DPOs that double head. So let me give you an example. Since, okay, this maybe I'll take a little bit longer on this item since I finished very quickly just now. I'll give you an example. So at a company I previously worked at, when I first joined, the DPO was also the chief risk officer parked under the CEO's office. So he double-hatted. He was the DPO as well as a chief risk officer. And when he retired, the function moved to the legal department where I was in. And our legal director double-hatted as the DPO. And because he had little experience in data protection and DPO duties, he hired a data protection manager with some experience to whom he delegated some of his duties and also got me to help out. And the three of us also worked with the company's chief data officer on data governance issues. And then when the legal director left, the function moved to cybersecurity, and a director at that department double-hatted as DPO. So the data protection manager also moved over to report to the cybersecurity director. And I personally think that parking the DPO function under all of these three areas are acceptable. I did not encounter any situations where there was a conflict of interest. What I think is a crucial point, though, is that if you want to allow your DPO to double hat, you need to make sure that the person does not perform or oversee the handling of personal data. Otherwise, they will be in a position of conflict of interest. In relation to reporting lines, I think it's fine for the DPO to report to the highest management level, because your DPO could essentially be your chief privacy officer. And I think it's also okay for the DPO to be one step removed, say to report to your head of legal or head of cybersecurity, but they should not be buried under layers of supervisors, because I think it can slow down the performance of the DPO's duties, including incident reporting and response. But there's something I need to flag out to everyone, and it's that the Belgian Data Protection Authority had previously fined 2 companies for lack of DPO independence under the GDPR. So in the first case, the company had appointed as DPO the head of compliance, risk management, and audit. And in the second case, the company had appointed as DPO the head of operational risk and information risk management and special investigation unit. So in these cases, the Belgian Data Protection Authority thought that there was a conflict of interest in breach of the GDPR's requirement of independence. Personally, I don't really see where the conflict of interest is, and these cases have been criticized, but you do need to be careful if independence is a requirement in Sri Lanka.
Thank you, Darren, for bringing that regional and international perspective into the answer. So in the interest of time, I'd like to move on to the questions raised by our audience today. So one of the first questions is that, and this is directed at all 3 panelists, so feel free to jump in, whether we can use personal data that we gathered when users use web-based systems for R&D or system development without explicit permission. For example, can a university use data for LMS, data of learning management systems for R&D work? I think this relates to purpose specification and purpose limitation. Anyone like to take a shot at this?
Yeah, I'll take that up, Shambhavi. So just to give some context, so one of the first thing is that even if you look at that question, we need to go a level down than that. So that's why, so when you say LMS, when you say student data, what data fields are we talking about? So, and the purpose why you are storing that data. So in terms of LMS, so I believe we are talking about a learning management system. So in that case, so the purpose of that, what you store against is going to be somewhere around student names to connection details, their course details, what they're studying, blah, blah, blah. So there are, what's the consent that you get at the point of entry for the system? And then when you say R&D, what purposes of R&D? Does that relate to learning management? Does that relate to academic? When you say R&D, what R&D are we talking about? But if there's a significant significant difference in terms of what you meant by R&D and what's the purpose of storing at LMS, definitely you would need a different consent. And I think you should not be doing that. I think you should not be processing personal data for a different purpose, which is in LMS. In terms of definitions from PDPA also, I think that's quite in line. And I think how you want to manage that is that you have different collection points. So if from a system point of view, I'm speaking, so different collection point of view, because for R&D, that's going to be a dump of the data that you want from LMS. So what you rather want to do is, why would you process? So for an example, you build the use case around not individuals, but rather a group of people, or rather, a set of class, and try to analyze you. Because if you want to look at a pattern, let's say we want to look at the 4 of us as a pattern of LMS, or do you want to look at a pattern of LMS of Mohan? So that is where the differentiation comes in, your logic of monetization, your logic of use case. If you want to look at as a whole, do you really want to look at as individual data, or rather a set of data where the personally identifiable information is not disclosed? So I think in that R&D purpose, how we want to define use case will define how you can get the L&D data or not. But definitely from top of my head, what I can say is you should not be using that because it's a different purpose.
Thanks, Mohan. So the next question is about how we should store personal data based on its category. I suppose this is based on whether it's special categories of data or non-special categories of data. I mean, I think if I may just elaborate more on add to this question is, do we need to take different approaches of storing data when it comes to the type of classification we might place the data in? So, Darren, Lankesha, Mohan.
Yeah, I'll take that. So I don't see the questions, Sandhini. What can you?
Yeah.
repeat?
So the question is, how should we store the personal data based on its category?
All right. So storage. So in terms of retention and storage, there are definite guidelines given. That is where some of your DPIA inputs would also come in. The protection impact assessment to identify what kind of critical data sets that you're having. So example, if you look at SPIA, where if you're into healthcare and you're storing sensitive information in terms of medical interests, and if you're into political activism and you're talking about religious beliefs, to all that, the sensitive categories of data, how you want to have additional security measurements, because in your DPIA, when you do the impact assessment, your risk is going to be high. So you might want to look into certain additional controls, but that additional controls might not necessarily be at a storage point of view. Storage is one. So you might consider encrypting and pseudonymizing and all that data in a certain way. But if you extend that beyond how you collect them, how are you going to transfer them in between? So all that also need to be considered, not only the storage of it. So I think yes, there need to be additional preventions, but that once again resides not on one place, not only storage, but on other areas as well. Why would you need to do that is simply because otherwise your DPIA and your protection layers would not justify each other. I think someone from the panel could pick up whether PDPA actually directs you to definitely to have additional controls on SPI. I might not comment on that, but from a program management point of view and from a governance point of view, your impact assessment and your action might not resonate together if you don't have additional controls in a certain way. That's quite as.
If I may add to what Mohan said from a legal perspective, I think the act, like Mohan says, so far doesn't say any particular storage differences, but of course they have to look at Schedule 2, where there are conditions for processing of special categories of data. But I think under the powers of the data protection authority also, I think there is power for the authority to come up with regulations on special categories of data. So I guess we are yet to see whether there will be any special conditions or regulations imposed on these areas. So I think we'll have to wait and see.
Okay. So yeah, I think there's a most recent question. I think we've been using a lot of acronyms during our discussion. The question is whether we could explain the difference between transfer impact assessment, privacy impact assessment, and a data protection impact assessment. I think the next session will be on DPIA, but any thoughts from the panelists, the nuances and differences between TIAs, PIAs, and DPIAs? Darren, if I may.
Okay, to me, there is probably a clear difference between transfer impact assessment and the other two. For the other two, I don't know, different people can use the terms in different ways. And to me right now, off the top of my head, PIA and DPIA are probably similar. I'll probably have to Google and check if anyone used it the other way. So far, I think in Singapore, people talk about DPIA, but not PIA. We also don't do transfer impact assessments. I think that's more common in countries which rely on the GDPR, which have the GDPR as their law. But transfer impact assessment, I think it's usually used where companies want to export personal data to other countries. So they have to do this thing called the transfer impact assessment to check on whether, usually to check if, to assess whether the laws in the other country provide adequate protections for the personal data they want to transfer out. And DPIAs, they are usually done when, for example, you are planning a new project which involves personal data and you want to understand what's going to happen with the personal data. So you probably record down what personal data you're collecting, disclosing, using, what the data flows are, what kind of personal data it is, volume, where it's stored, where it's going, and then you figure out what the impact is to the individuals from whom you're collecting the personal data. You assess risk. So it's a bit similar to the DPMP, except that this is much more focused on personal data itself.
I think we're supposed to take a 10-minute break right now, but I thought we could, if the panelists are open, take the next 10 minutes just to answer the questions, if that's all right. Okay.
Yep.
Yeah. Another question that has come up is, I think maybe something Lankisha could answer. What would be the nature of litigation surrounding and involving the PDPA may look like in the future? I think there's a lot of anticipation.
Sorry, Sandhini, I didn't get the question.
So what would
on
be
the Data Protection Act?
Yeah. What would be the nature of litigation surrounding and involving the PDP?
Okay. Nature of litigation. So I guess well, it may be too early to tell, but litigation in terms of we've seen, like, once the GDPR was implemented, we saw how there were litigation around it, but maybe certain areas such as the companies which are supposed to follow certain procedures like the breach notification, or even from the data subject rights, right? There are conditions on and timelines where you should revert to the data subjects, and with regard to implementing their requests on erasure or modifying, also things like that. So those also, if not followed by the controller, I think the controller could be looking at legal consequences. So those might be, I think, from the terms of data subject rights, I think those might be more inclined to litigation. But of course, the other area would be a breach of confidentiality, and privacy. So in terms of leakage of information. So those are the possible areas from this point of time I can think of the possible areas for litigation.
Thanks, Rakesh. So the next question I'd like to direct it to Mohan, perhaps. Is there any guidance on records of processing activities and what information is needed to be recorded?
Okay, so we call it in short terms ROPA, record of processing activities. So we go for wider spectrum of recording activities. So there are, once again, there are tools to do this. Some people use tools, some people use just an Excel sheet to go ahead and do the ROPA. So where the information is originated, where the information is coming from, where are they stored from, what are the legal purposes that primary purpose and any other affiliated purposes by different divisions that you use from, who would have access to this particular information, and what business process is that information is used for, and who is that accountable person, or rather the business unit head or the data champion who is there related to that storage, that information. And then then there's going to be a whole after the purpose or other processing part of it. That's the first part, the processing, why, where, how, and all this information. And then in terms of storage, where are you storing that, under what database, under what system, where are they storing, and is it a cloud, is it on-prem, where is it stored, how are we storing it, what are the systems that are accessing it, apart from people, integrations, and APIs. And then we look at in terms of retention, how long are we retaining this data, and in terms of purging or data destroying, what's that mechanism of doing it, who are accountable for that. So all that goes to a ROPA. So before we come into ROPA, what we follow usually is we do a data flow map. So we go by each process and we draw a data flow map on that particular personal data. Then let's say some visitor coming to one of our plants and there's a giving their passport details to, as a visitor under visitor management system, you input that data. Simple example. So we have the visitor management or other visitor registration process. So then we map the flow where these points are at, and then only we work with the ROPA, where record of processing activities, each and every line is by data field, by data name, we capture all this information throughout the life cycle.
I think right now there is is there a guidance that controllers can rely on in the absence of data protection authority being in existence?
Sorry, was that for me, Sandhani?
Yeah. Sorry. Is there any guidance you can rely on, or like?
I think I'm not sure whether I'm equipped to answer that. We would follow the best practices. Okay. So because our general guideline was around GDPR, right, and ICO guidelines around what UK was doing around, because ICO gives extensive guidelines in terms of how the ROPA can be handled and what are the fields that need to be captured. So Information Commissioner's Office UK has given a very explicit guideline around it. I think that's a point to start maybe, but PDPA wise, I think I'm not sure whether that's what are the exact fields around that.
Okay, thanks, Mohan. So there's another question I think I'd like to direct you, Darren. Is the DPO responsible for the organization or for the data subjects?
Okay, interesting question. To me, I think that the DPO should not be taking sides. I see the DPO as similar to being in a position of an in-house lawyer for the company, where you are employed by the company, you report to someone, but as a professional, you should always maintain your independence. And if you see the company doing something that's not right, you should speak with the person you're reporting to, senior management, the board, and how to make things right. I wouldn't go so far as to say that the DPO is responsible to individuals. I'm not sure if any jurisdiction says that the DPO is responsible to individuals.
Mm-hmm.
Yep.
Thanks. Darren. So I think we have time for perhaps one more question, one or two perhaps. So the question is, when it comes to, what would be the areas? So I think something I'd like to direct to all three panelists. What would be the areas we would have to think if the organizations are moving to clouds as lift and shift, and then do re-architecturings?
Okay, so moving into cloud. Okay, once again, I'm assuming that already your data sets are subjected to you're already using personal identifiable information. And moving into cloud, what moves the needle is on the security of it, right? So the principles does not change. So it's just the host of data. So you already had it on-prem, now it's on cloud. So how we want to look at is if you already had certain processes around data, the on-prem or the co-located or data center located data, how are you going to ensure that what you had here is going to be established in cloud? Because the principles won't change for you. So in terms of cloud, now the questions of data jurisdictions, where the data origination happens, how are you going to store all that happens. But how we manage, I can speak for ourselves. When we move to cloud in certain systems, we have the exact requirements communicated to the cloud service provider, and we build conversation and we try to understand how are they compliant. Sometimes it's not exactly the same way as how we do it, but we try to understand whether that those storage and processing principles are there, the controls are there, and we get help from external or other third parties to validate whether cloud service provider is doing the right thing and they're compliant to those standards, and get it validated. You are going to have okay, practically speaking, you will have certain to a certain level of I would say increase in cost. So you might need to invest in certain bit, because if let's say on-prem running encryption tool or data at rest encryption tools might not necessarily be adopted, because you might have a perpetual licensing on doing that right now on-prem, but you are moving into cloud, you are pretty much looking at a one-third kind of one-third, one-fifth, or rather even half of it, 50% of it, an increase in terms of your OPEX that you're going to incur. That I'm giving a very usual baseline that we usually have it in industry, because there's going to be a cost increase for all those technologies. But shifting there in terms of jurisdictions, you would have to stick to the guidelines and the principles laid out by the PDPA. What jurisdiction are you moving? How are you going to contractually manage that? And then because you are going to now impose a data processor on your behalf, how are you going to manage that third party, and how are you going to manage that relationship, and how are you going to manage that with your consumer and consent and all that piece with that data processor coming into play? That's totally around, that guideline is, I think, pretty much clear around PDPA. So how a data processor need to be onboarded. Apart from that, technically things that I spoke of need to be considered.
Thank you, Mohan. I think that's all the time, unfortunately, we have for the panel discussion and Q&A. So I invite the panelists to, if they can see the questions, just to respond to any question that they see in the chat. And so thank you again to Darren, Lankisha, and Mohan for taking their time and to speak to our audience today and sharing your thoughts on data governance, data protection management program, and the role of the DPO. And thank you so much for the valuable insights shared during the last 1 hour, over the 1 hour. Thank you.
No problem, Sandhini. It was a pleasure.
Thank you.
Thanks everyone for attending this workshop. It was fun.
Thank you.
Yes. Thank you, everyone. Okay.
But
Thank
you are
you.
welcome to hang around. So. All right. So the next session would be on data protection impact assessment. So let me, since we're not going to go for a break, let's just start right off. I hope you can all see my screen. Right, so in the next 20 to 30 minutes, I'd like to take you through over the provisions of the Personal Data Protection Impact Assessments, which is included under the Personal Data Protection Act. And so under Section 24, there are certain mandatory requirements where a controller must perform a data protection impact assessment. So this is an obligation that is vested with the controller. So whenever a controller is engaging in a systematic and extensive evaluation of personal data or special categories of personal data, that's what SCPD stands for, including profiling, then it is mandatory that he conducts a data protection impact assessment. So, for example, the Act doesn't really go into what exactly systematic and extensive evaluation of personal data protection would involve, but we could assume that this would include processing activities like credit scoring, or predictive analysis, or predictive decision making based on analyzing behaviors of consumers, risk profiling, for example, things you do for legal requirements, sometimes under the FDRA, Financial Transaction Reporting Act, and so on. And if you are doing things like, location tracking or tracing individuals and so on. So if it's systematic and if it's extensive evaluation of personal data or special categories of personal data, data protection impact assessment must be mandatorily done. And in addition to that, if the control is engaged in systematic monitoring publicly accessible areas, that is, you have certain publicly accessible areas monitored through CCTV systems, face recognition technologies, and so on, or you are engaged in monitoring of telecommunication network, either as a service provider or as a maybe even as a law enforcement agency, then it's important that a DPI is conducted. It's mandatory that DPI is conducted under the PDPA. In addition to these two categories, the Data Protection Authority can also prescribe certain conditions or certain activities which it deems mandatorily a data protection impact assessment should be carried out. And in that regard, controllers who would continue to process or engage in processing activities which falls within an activity that is prescribed by the DPA will have to do a DPIA in the future. So Section 24 goes a little further in terms of the scope of DPIAs. So the idea here is to ascertain the impact of the processing of the intended processing activity on the principles of data processing, which you find under Part 1, which Lankish also spoke about, and the rights of data subjects. So the rights of data subjects recognized under Part 2 of the Act speaks about rights like right to access, right to withdraw consent, right to object to processing, right to rectification, right to erasure, and request review of automated decision making. So it's important that a controller try to assess and analyze the impact its intended processing activity has on each of these sectors. And in addition to that, it's required that the controller take into account the measures and safeguards which will be taken to mitigate the risk of harm to the data subject. So these risks of harm could be in relation to any rights that are guaranteed by law, or whether whether the data processing activity limits the exercise of data subjects' rights recognized under the Act, and so on. So it could be various types of risks of harm a controller should identify during this process, and it must also so the DPI must essentially take cognizance of the measures and safeguards taken to mitigate these risks of harm. And it's also included under Section 24 that it's a controller must obtain the assistance of a data protection officer, particularly if that organization is mandated to appoint a DPO under the Personal Data Protection Act. So for some controllers or processors, having a DPO is not mandatorily required. But if the Act requires that a controller processor must have a DPO, then when you're conducting a DPIA, the assistance of the DPO must be obtained. And although this is not specifically mentioned in Section 24, one of the important things to factor in here is that it's not just the DPO's role to do a DPIA, it's a collective effort which the organization or the relevant stakeholders within the organization should be involved in. Like, for example, if you're launching a new product or new service, because a DPO alone would not assess the risk and the issues within that new product. So it's important that he's assisted by the relevant internal stakeholders, whether it be the marketing team, whether it's the sales team, the IT team, to advise them about their ongoing practices and work as a team in terms of achieving the objectives of a data protection impact assessment. And Section 24 also provides that the controller can consult the Data Protection Authority, the DPA, if they're not in a position to mitigate or provide for safeguards for the risks identified during the data protection impact assessment. This is called prior consultation process. So it's still discretionary, so it's not mandatorily required. But if the controller is not sure about the measures he has taken or the safeguards he intends to take, he can always consult the Data Protection Authority for guidance. And the authority, during its consultation process, may advise either to cease the data processing activity or do, take certain action in order to mitigate the risks identified through the DPIA process. And it's also important that a fresh DPIA is conducted whenever there's a change in the methodology, technology, or process in which a DPIA has already been carried out. So change of methodology or technology may relate to, where you change from an on-prem solution to a cloud solution, or you move away from, paper-based data collection mechanisms to digital data collection mechanisms, or you decide to outsource a certain operational activity to a third party, which was so far has been conducted in-house. So in various kind of situations where the context or where the status quo changes, which would have a bearing on the risk that you have identified so far in a DPIA, it's important, it's actually mandatory that you conduct, as a controller, a fresh data protection impact assessment on those new changes. So the Data Protection Authority, which is yet to be set up, is expected to provide for the procedures, the forms, and the way to conduct a DPIA. So it's important, but nevertheless, it's important that we understand what the kind of process that is involved in a DPIA, so we are prepared for what's coming in the next few months. So even because you can always rely on, Darren spoke about the guidance given under the PDPC, and Mohan spoke about the guidance available in the Information Commissioner's Office of UK, which provides for a variety of tools and guiding notes on the process of doing a DPIA, which you may find useful at this point in the absence of having rules by the local data protection authority. So this is just a summary I've prepared in looking at all these different publicly available guidances. So the initial requirement is to assess the need for a DPIA and then plan for a DPIA. So if you are doing a processing activity which is prescribed by the Act that you must do a DPIA at the outset, then that's one box ticked, and that means that you will have to do a DPA. And especially if you need to realize whether you are doing, for example, if you are doing systematic evaluation, or if you're doing profiling, or using, processing large scale of special categories of data, special categories of personal data, then it's likely that you might have to do a DPIA for that particular processing activity. And then you need to plan DPIA where you identify the relevant stakeholders related to that processing activity, define the timelines, identify the data champions or the process owners and so on. So once you do plan the DPIA, the next step would be to identify the types of personal data and the data flows. So in a particular, if you're thinking about a particular product or a particular service, as a controller, you might be collecting a host of personal data. It could be, the basics, the name, the address, and so on, but it may also involve certain special categories of data as well. So you need to identify what data types you collect, and then identify the data flows. So where you, the point of collection of data, whether you're sourcing it directly from the data subject or whether you're sourcing it from third parties, and how the data flows within the organization. I mean, where it's going to be stored, with what are the entities this data would be shared with, are there any third party entities who would be interested in this data, and so on. And then this will help you once you map this out. I think something Mohan also spoke about, you would realize whether there are any potential risks involved in the whole process. So it's important, as a next step, you assess the potential risk, including the likelihood and severity of the risk. So there's a risk categorization you can employ in this regard. So these risks, it would not only relate to, information security risks, but also in relation, the risk in terms of the principles of processing as well. So you need to look at whether whether the processing activity complies with a lawful ground recognized either in Schedule 1 or Schedule 2 of the Act. So, if you're collecting it based on consent, or whether, you're collecting it further to a legal requirement or any contractual responsibility, and so on. So this would help you to really understand what data you're collecting and why you're collecting it, and how it would translates to a lawful basis under Section 5 of the Act itself. In addition to that, you need to look at the other principles of processing as well. So what are the purposes, and whether the processing activity itself is, following purpose specification guidelines given under Section 6, and purpose minimization or data minimization requirements under Section 7, and so on. So there you need, as a controller, you need to really assess the risk involved in whether the processing activity complies with the principles of processing, and how far you can give effect to the rights recognized in the Act itself. So the fourth step would be to develop methods and implementation strategies to identify the risk. Now, for example, if you see that you rely on consent for a certain processing activity, and then it's important that you also give effect under the Act, that you also give effect to withdrawal of consent as well. So if your new system or if your new product is not designed to give effect to withdrawal of consent, then that's a problem for you as a controller. So you need to develop a strategy or a methodology as to how you can give effect to withdrawal of consent in certain circumstances. So this may require you to perhaps revisit if it's a software, revisit the design of it, or whether how else you could give effect to these requirements under the Act itself. And the fifth step is to monitor the effectiveness and the methods of the strategy. So it's important that a DPI is always put on record. So everything, starting from ROPAS to all these, the methodologies, your risk assessment has to be documented thoroughly. And once you implement these strategies, there should be a way where you can monitor the effectiveness of these strategies as well. And finally, it's also important to update a DPIA to reflect any changes that would, come along, come over time, which relates to processes or address new risks and so on. So, so I was thinking we could, try something a bit, practical and to, take a very short case study in the interest of time, and look at how, we have about 10 minutes for this. So how we could actually do like what are the considerations that should go in for a DPIA for a product of this nature. So the idea here is that there's a company which is launching a mobile gaming application, which will collect, store, and process following personal data. So they're collecting name, email, phone number, and picture because they want to identify and contact the user and create a user account. They want to age and date of birth just for the purpose of recording the age, and they are collecting gender to provide personalized gaming experience, device IP or ISP details, as they mentioned, for technical purposes, location data, chat history, and they also source certain data from third-party sources, including social media, to provide personalized services. This is kind of, a generic gaming application you might be familiar with. And the data is going to be stored on a secure cloud platform hosted by a third party. Data is not going to be encrypted either in transit or when it's at rest. And also one of their subsidiaries will have access to user account, contact details to conduct marketing campaigns with third parties. And user data may be disclosed for product innovation purposes and for law enforcement agency requirements. This is a hypothetical product anyway. So the data retention period is not specified, but generally as a practice, they would retain it for 6 years. And users can request account to be deactivated, but they cannot request account to be deleted. And they have to agree by the general terms and conditions, which in part contains the terms on personal data processing, and there's no separate privacy notice seeking consent. So in a situation like this, I think it's, if you go through the process I just illustrated a little while ago. So in this case, it's likely, let's assume, for instance, it's likely that you have to do a DPIA. And when you come to second step, you need to identify the types of personal data and data flows. So when it comes to that, I think this is a very, very high level data flow. And it's, I think Mohan would agree with, if he's around, I think would agree with this is not how a data flow would look like in an actual DPIA. But this is just to give you like a basic idea. So you have the user here providing information to XYZ application, which is a controller in this regard. And the data goes, and they also source data from third-party sources. And the user may have provided to third parties at some point. This could be your social media account, because sometimes when you register for certain applications, you incline to use your social media accounts for registration. So the data then goes to a third party cloud, the storage, and also some of it goes to their XYZ Marketing Limited, which is their subsidiary. And they may have also access to other subsidiaries of the same company, and also for law enforcement agencies. So the idea here is that you just understand this. Again, this is, like I said, it's a very high level illustration. So when you identify the types of data that is needed, so you see that they're collecting not just personal data, but also special categories of personal data, because age, gender, and gender is involved, and there is no indication, and the indication is only for app built for adults, so they might be collecting information related to children as well. And it's not specified whether they have any particular age gate management condition, but so if you're collecting all this data belonging to children under the PDPA, it all becomes special categories of data. So then once you identify the types of data that are involved and the data flows that are where the data flows within the organization, it's important to identify where each of these data flows, where the name goes, and for what purpose it's collected, and whether you can map it against the lawful grounds recognized either under Schedule 1 or Schedule 2 of the Act. So this is where it will help you to assess the potential risks involved. And when you talk about risks, there are certain, you can take, I think, what you see on the left is from the PDPA's Guide to Data Protection Impact Assessment about the risk matrix. So, you have the likelihood criterion and you have the impact criterion, and where you each assign a score for each of these. So based on your internal operations, you can assign the likelihood, or you can ascertain the likelihood, as well as the impact of a particular activity, a particular situation, and then categorize it according to the risk matrix. And generally, anything above 15 is considered to be high risk. So for example, at the point of collection, if you're not adhering to data minimization requirements, see, for example, in this, if you take the same example and see, they're collecting gender to provide personalized gaming experience. And, it may not really map very comfortably with either Schedule 1 or Schedule 2, because unless there is explicit consent provided for it. But as you can see underneath, there is no separate notice seeking consent. It's just something that is embedded to general terms and conditions, which something you cannot do under the PDPA. So this is a high risk in terms of collecting gender, for example, in this particular application. And if you take another example, such as email and phone numbers, you will see both of these details are collected. Sorry. Both of these are collected for the purpose of identifying and contacting the user. So you might question whether this actually maps against the requirement for data minimization, because the requirement, I think in Lancashire's presentation was also explained how you need to only collect what is necessary and adequate, and it should be proportionate. So in terms of that, do you really need both an email and a phone number to identify and contact a user? So these are certain risks that you may look at and categorize according to the likelihood and the impact. And therefore, then you can really devise what measures and safeguards you can take in order to mitigate those risks. So risk scenarios can crop up when it comes to rights of data subjects. For example, in this case, you would see that the users are not in a position to have their data deleted. So the system architecture does not allow for that, and they can only be deactivated. So this is a high risk, which the controller of XYZ company needs to address and have it rectified during the DPIA process. So this is roughly a very high level or brief overview of the data protection impact assessment provisions which you find under the PDPA. And if there are any questions, please put it on the Q&A so I could type in the answers during the next session. So without any further ado, I think I wrap up for the moment and hand over the session and commence the next session on cross-border data processing. Thank you very much. Okay. So for the next half of our workshop, I'm thrilled to have with us Dr. Ralph Saar, who is joining us from the European Commission, and he's the Deputy Head of Unit in relation to cross-border data flows at the European Commission, and someone we've closely consulted during our PDPA process as well. And thank you so much, Dr. Ralph, for joining us this evening. And next, for this session, he's joined by Mr. Jonathan Fernando, who is the General Counsel of ICTA, as well as Director of Sri Lanka CERT and Chair of the Personal Data Protection Drafting Law Committee. So the floor is open to Dr. Saar for his initial presentation or speech.
Good afternoon. I guess it is early in Sri Lanka from Brussels. My name is Ralph Saar. I'm indeed working for the European Commission, so the executive arm of the European Union in a department that deals with international data flows and data protection, so all the international aspects of data protection. For the presentation, I sent relatively late my PowerPoint presentation, so I just was wondering whether there is a possibility to launch that on the screen. That would then make it a bit easier, perhaps, for the audience to follow. If that is still...
Send it to me or to...
I sent it to the contacts that I had. Okay. So the organizers in general, okay. I don't know whether, I didn't check whether you in particular were in copy of that. Let me...
I have it, yeah.
You have it? Okay, yes. Great.
Let me put it up.
Excellent. And then I don't know, would it be you who moves through the slides? Okay, so I would then always indicate when we go to the next. And it's a long slide deck, but I will not always go into all the details, but it can then perhaps also be shared with the audience if that's of interest, or be put on the webpage for future reference. So what I wanted to talk about and what I've been asked to talk about are the rules, the legal framework under EU data protection law for cross-border data transfers, and the instruments that we have put in place on that basis. And then I wanted to at least for some of these instruments also point to more global trends that we see around the world in our work on facilitating data exchanges with third countries. Next slide. So what I want to do is first to provide a short overview of the instruments that are available under EU law, say a few words about some of the overarching general principles that guide our work on these instruments, and then spend a bit of time on 2 or 3 of these instruments in particular, which are, in my view, the most relevant and important ones that we have, and that concerns namely adequacy decisions, and then model data protection contracts, which we call standard contractual clauses. And then I will say a few words also about certification mechanisms. Next slide. So in terms of our EU legal framework, and I'm describing this for the commercial sector and but also for the public sector outside criminal law enforcement. For these areas, we have a law which is called the General Data Protection Regulation, short GDPR, and that law has a specific chapter on international data transfers, chapter 5, and in that chapter you first see you find some general principles on cross-border data transfers, and then one by one the different instruments. Adequacy decision as the most comprehensive tool comes first. Then instruments ensuring what we call appropriate safeguards. That brings together a number of different instruments, and I will get to this. And then there are certain statutory grounds for data transfers, such as consent and others, and I will also briefly refer to them at the end of my presentation. Lastly, there is an article on cross-border enforcement cooperation, so cooperation between supervisory authorities, data protection authorities, which of course also involves the exchange of information, including if it's sort of a second generation form of cooperation, including also personal data in the course of investigations, for instance. And just to mention briefly on that, because I will not dwell further on Article 50, there's also an important multilateral arrangement, which is called Convention 108 plus, which is right now open for signature and ratification, and which has a dedicated chapter on cross-border enforcement cooperation, which is perhaps worth mentioning because it's an arrangement which brings together already now 55 state parties from around the world, and it's growing, and it's therefore quite useful perhaps for supervisory authorities if the country joins that convention, because it would already provide a framework and a network of enforcers that can then cooperate on the basis of the convention. Next slide. So in terms of general principles, the starting point for the GDPR and EU data protection law in general is the protection of personal data as a fundamental right. And with that comes the recognition that protecting data only domestically would be incomplete, given that it's very easy to move data across borders. And that's why we have a dedicated chapter on cross-border data transfers, which seeks to ensure the continuity of protection. So when data travels, the idea is that the safeguards travel with the data to the extent possible, and that in particular the safeguards that are afforded domestically are not undermined by moving the data outside the jurisdiction. And that might involve even going a bit further than just the initial transfer. The processing chain might be longer, and there might be onward transfers. So after the initial transfer, a further transfer within the third country or to yet another country. And at least to some extent, our rules also try to address that particular issue of onward transfers. And require in particular that the instruments that we put in place also take onward transfers into account. And then just to say that the article on the general principles also makes clear that, of course, data transfers are just one particular form of data processing. among other forms of processing, like such as storage, use, manipulation of data. And that, of course, means that the data exporter not only has to comply with the specific cross-border requirements, but also with the general requirements for data processing, such as purpose limitation, transparency, and data security, just to name a couple of the relevant principles. So those requirements come on top of the specific cross-border transfer rules. Next slide. So with this, I come to the first and one of the most important transfer instruments that we have under the GDPR, which are the so-called adequacy decisions. Next slide. An adequacy decision is a declaratory decision by the European Commission, so my institution, that finds that a third country or a part of a third country, a territory within the third country, or a specific economic sector within a third country provides an adequate level of protection. And I will get to what that standard exactly means. So it's a finding, and on that basis, data can flow freely from the European Union to the third country. In a way, the third country is treated as if it was part of the, for the purposes of data protection, as if it was part of the EU internal market. And so an exchange with a data importer in the third country is treated as if it would take place within the European Union. That's the effect and benefit of an adequacy finding. And that's why it's the most comprehensive transfer instrument that we have. Next slide. And so I've already, in a way, to some extent, addressed the specific benefits, because it in a way assimilates the third country to a member or part of the EU internal market. That means there are no further requirements for notification or authorization of the transfer. Of course, the normal data protection requirements still apply. And that, of course, means there's no need for further transfer instruments, and that reduces costs and makes it, of course, easier to transfer data. And that's the specific benefit of adequacy. Next slide, please. In terms of countries that we have found to ensure an adequate level of protection, you can see that that's, of course, not by no stretch of imagination the whole world, because an adequacy finding involves an in-depth assessment, and that takes also some time, and that's why we have only a limited number of adequacy decisions so far, some of which have historical reasons. They concern countries or sometimes it's even territories that don't have the status of a country, which are very close to the European Union, or even in a way geographically inside the European Union. But we have in more recent times, in particular, focused our work on adequacy on countries where we have considerable, large amounts of data flows, such as Japan or Korea, and we have just this week on Tuesday published a draft decision with respect to the United States, and we have also, for instance, adequacy findings with respect to Canada, Switzerland, or Israel, and some countries in Latin America, such as Argentina or Uruguay. And there are ongoing adequacy dialogues with a number of additional countries to do the same. Next slide, please. Just very briefly, I will not go into a lot of detail on this. Of course, the term adequacy had to be interpreted to determine what it really means, and our highest court, the Court of Justice, has interpreted as meaning that the third country needs to ensure a level of protection that is essentially equivalent to the one within the European Union. and basically on account of what I explained earlier, namely that the third country will be treated as if it was part of the EU internal market. So the benefit of an adequacy finding also comes with a relatively high and demanding standard to be applied. And this has been further developed in the case law of the Court of Justice. And there are also certain guidance documents by the EDPB that stands for European Data Protection Board, so the entity that brings together our data protection authorities. Next slide, please. Just briefly an overview as to what we look at in an adequacy finding. We have to look at two aspects. On the one hand, sort of the commercial side, which safeguards apply to, let's say, the data importer, typically a company in the third country. And there we look for certain data protection principles, core data protection principles, rights of individuals, independent oversight by a dedicated supervisory authority, and individual redress. But we also need to look at the conditions, so the limitations and safeguards that apply to access by public authorities of the third country to data that has been transferred to the third country, again from the same optic, to ensure that the protections are not undermined, including by interference or access by public authorities. So also there, we look essentially as to, we check essentially whether the conditions and safeguards are there to ensure that what we call the principles of necessity and proportionality are ensured, and that there are redress possibilities in the third country. Next slide, please. The adequacy tool is also a rather flexible tool. There can be full adequacy for all sectors of the economy and for the entire country. There can be partial adequacy, as we have it, for instance, for Canada. Only certain economic sectors are covered by their data protection law. Sometimes an adequacy finding can be subject to additional safeguards that the third country puts in place specifically for data transferred from Europe. That's, for instance, the case for Japan and Korea. Next slide. I think this I will essentially skip. There is a certain procedure, just to say it involves not just the European Commission, so my institution, but also in particular the data protection authorities represented through the European Data Protection Board that has to give an opinion, and it also involves our member states. Next slide. And then with an adequacy finding, the process doesn't stop. There is also a requirement under the GDPR to then monitor further developments to see whether, for instance, legislative developments that could affect the adequacy finding. And then we also carry out in certain intervals a joint review together with the third country, where we look at what has happened in the preceding years. Is there anything that needs to be addressed? And then we usually write a report on that that we make public. Next slide. So that's the adequacy finding. And then we have a number of instruments in Article 46 that seek to ensure appropriate data protection safeguards. That's a notion that our court has again interpreted as meaning a comparable level of data protection in the third country when compared to the European Union. Next slide, please. And there are essentially, let's say, three categories of instruments. There are certain contractual tools. There are certification mechanisms and code of conduct. And then there are sort of international arrangements, binding arrangements, international agreements, or administrative, so non-binding arrangements, which then, however, require the approval by the data protection authorities. And the most important ones, I would say, are the contractual tools and perhaps the certification mechanisms. And among the contractual tools, we have two types. We have data protection contracts that set out in a contractual form data protection safeguards, and they can be either tailor-made ad hoc, or, and that's much more important, model data protection contracts that we have developed and which are pre-approved and can be used by parties to transfer data. And I will come to that. And then for corporate groups, we have binding corporate rules that also require approval by the data protection authorities, which a corporate group can design itself as long as it ensures appropriate data protection safeguards within a group. So for exchanges among parent companies and subsidiaries, for instance. Next slide. Just a few words on what we call standard contractual clauses. So those are model data protection contracts, which in fact support the majority of data flows from the EU to third countries. There are certain estimates that they support around 85, perhaps even more % of data exchanges or data transfers from the EU to third countries. And they are clauses that the two parties, the data exporter in the EU and the data importer in the third country, can choose to rely on. They are voluntary in their use. But if they use them, they have to take them as they are. They are pre-approved. They have been drafted by the European Commission, again, following consultation of the data protection authorities. And because they are pre-approved, they can be relied upon directly, but they can also not be changed. They only require that certain information needs to be added, describing the specific data transfer and perhaps specific security measures and measures to protect sensitive data in the annexes, but the body of the model clauses has to remain unchanged. And they create third-party beneficiary rights, meaning that the parties have to agree that the individuals concerned whose data will be transferred on the basis of the clauses can invoke them and can enforce them, including in court. And in particular, the data importer needs to submit itself to the jurisdiction of the competent supervisory authority of the data exporter, and to the national courts in the EU. That's in particular there to ensure that individuals have an easy way to seek redress. And it's of course also relevant because there might not be a data protection authority in the third country, or it might not be possible to invoke data protection safeguards in the courts of the third country. And hence all of this is brought back to the European Union. Next slide. So why are SECs the most used transfer tool for transfers from the EU? It's essentially because of their considerable benefits that they present. As I said, they create their own data protection regime at contractual level and can therefore be used with any country around the world, whether it has a data protection regime or not, and how strong the data protection safeguards are, because at contractual level, the data importer has to commit to certain safeguards. That also brings a lot of transparency and legal certainty, and in a way, a harmonious level of protection that companies can then know and will abide to in all the contractual relationships when this involves data transfers. And it's low cost because companies don't have to negotiate these clauses. In fact, they cannot negotiate them. As I said, they have to rely on what has been pre-approved. And that is particularly useful for small and medium-sized companies that cannot afford more costly and time-consuming options. And I will come to this very briefly at the end. Next slide, please. Just to say, we have recently modernized our standard contractual clauses, and I have put the link to these new clauses into the slide. And there's also a guidance document which answers to a number of questions that have been raised. And I would leave it at that. Next slide. Just the last words on model data protection contracts. It is not just the EU that is using this tool to a very large extent, but it is also increasingly used around the world. And I'm just pointing to the model contractual clauses, so they call them MCCs, that have been developed by ASEAN, so the Association of Southeast Asian Nations. and also by the Ibero-American Data Protection Network. So for all of South America and Central America. And currently MCCs are also under development by, under Convention 108 that I referred to earlier. Next slide. Just briefly, there's only one slide on this, on certification mechanisms. That is, of course, also can be a useful tool. So a mechanism whereby the data importer can certify against certain standards, and there is a certification body that carries out the certification and then monitors compliance with the criteria. But the important thing is that it has to be, if one really wants to rely on that, there have to be certain requirements, and under the GDPR, a certification mechanism means that there have to be binding and enforceable commitments by the data importer, and that these commitments create rights for data subjects that they can invoke and enforce, and that they're effective legal remedies. We have not yet put in place this mechanism. We are just waiting for the guidelines by the European Data Protection Board to come out very soon. And then I think this will take off. Just to say, a certification, of course, because of the need to go through a certification process where your operations are going to be checked, is both time intensive and resource intensive. And hence, I believe at least that they are better suited for larger companies. They're not very ideal, I think, for micro, small, and medium-sized companies. And you can see this, for instance, for the certification mechanisms that has been developed under APEC, the APEC cross-border privacy rules, which are there for more than 10 years now, and only 40 companies have certified in this entire period. And if you look at these companies, they're all multinational companies, large companies that have been able to afford that. Last slide, and then I stop. Just to briefly mention, we also have a number of statutory grounds that a transfer can be based on, but only ad hoc transfers. So our rules make clear that this cannot be used for ongoing structural exchanges, repeated exchanges, or massive large-scale transfers. So for ad hoc transfers in individual cases, a data exporter can rely on the explicit consent of the individual. There is a ground when data needs to be transferred to perform a contract. So if I book a hotel, I might have to send personal data, or my travel agent might have to send my personal data. So that can be a ground for transfer. Important reasons of public interest or vital interest of an individual in an emergency case, and then, but under very strict conditions, legitimate interest. So there are certain grounds, statutory grounds in specific cases. I'm sorry, probably I have gone over time, but that concludes my presentation, and thank you very much for your attention.
Thank you very much, Dr. Sao, for that very comprehensive overview of the provisions related to cross-border data processing under the GDPR. So I'd like to move on to Mr. Fernando now, and to bring in perspectives from the PDPA and to share thoughts on the same. Over to you, Jen.
Thank you, Sandhuni, and nice to see you, Rav. Just a minute until I close my slide. Can my slides be seen, Sandhuni?
Yeah, Jen.
Yeah. So thank you very much to the Ceylon Chamber of Commerce for putting together another important session on the Data Protection Act number 9 of 2022, which was drafted after a number of consultative processes. It was a open, transparent process that led to the completion of this draft. I just want to particularly acknowledge the support given by my colleague Sanduni and the team at Ceylon Chamber, and very specifically the role played by Ralph and his team in giving extensive expert comments right through the process that led to the completion of the drafting of the Data Protection Act. So in fact, over the years, due to the work Sri Lanka has had through a number of channels and the fora provided through the Council of Europe, mainly through the TCY, or the Budapest Cybercrime Convention Committee, which negotiated and drafted a new instrument called the Second Additional Protocol to the Budapest Cybercrime Convention over a 4-year period. And that instrument was opened up for signature in May 2022. In the run-up to the negotiation of that particular important instrument for gathering of electronic evidence from cloud services, many of these aspects relating to cross-border data transfers, data processing was extensively debated and a negotiated area. And having participated in those processes, we gained insights to the practicalities and the nuances relating to the subject area, which in a way got reflected right through the drafting process. And I just want to particularly acknowledge the role played by Dr. Ralph Sau and his colleagues from the International Data Flows Division at the European Commission, and for the dialogue and the friendship continued right through that period when we had to gather answers to areas that were not even clear to us. So Section 26 is the relevant provision in the Data Protection Act number 9 of 2022, which is relevant to the subject under consideration in this session. I'll be very brief because I'm also recovering from a cough, so I will be, I'll finish very soon. But this particular section relating to cross-border data processing and cross-border data flows was under extensive discussion, and several rounds of changes went through right through the drafting process, as may be visible, and those who took part in the drafting process would be aware that when you look at the substantive provisions that were available in the original framework document that was submitted for public consultation in middle of June 2019, and thereafter the subsequent revision upgrades published online starting from 19th September 2019 right through 2020, 2021. And even if one were to look at the Gazette supplementary version of the bill published on 25th November 2021 to what we have now, through new additions, further refinements, amendments to Section 26, you will see multiple differences over 3.5 to 4 years. So in the early days of our drafting process, the thinking was that there should be some degree of localization. In our public consultations, the government stakeholders, namely the public authorities, wanted that. And By that time, we all know the government's digital agency, in collaboration with the private sector, had set up a government cloud called the Lanka Government Cloud, or LGC. In that context, the paramount consideration was localization. But right through the public consultation process and in our interactions with our stakeholders, especially from the private sector, it became very clear that a mandatory localization approach would not be sensible and would put the private sector entities into a difficulty. And then it became obvious that if we were to give flexibility for private sector, there may be government entities involved in commercial operations. We are a country where we still have what we call state-owned banks. Their competitive advantage would be impacted if those government-owned business undertakings were not given the same level of flexibility that were to be given to the private sector. So these discussions matured over time. And thereafter, we consulted our friends at the European Commission, friends like Dr. Ralph and his team, and got insights to the cross-border data flow issues and challenges, and the way forward for countries and the best practices available globally. Based on those insights, we were able to come to a decision that is reflected in our presently formulated Section 26. So unlike many countries that have got a number of provisions dealing with this subject area, as we see from the instruments in the European Union, there are a number of provisions that govern this subject area. We have tried to compress the issues that need to be addressed in a singular section with number of subsections, so that we have a singular point of reference through which this subject could be looked at when somebody reviews the Data Protection Act number 9 of 2022. So if you look at these boxes that my colleague Sanduni was kind enough to do for me, we see the degree of localization that is permitted or required for public authorities. And remember, when we look at the definition of public authority as amended when the bill went to Parliament, it does not include government-owned business undertakings now. So public authorities are ministries, departments performing functions pursuant to a written law obligation, and the definition is rather narrow. So broadly, public authorities are required to store data within the country. However, there is an exception provided where the future data protection authority, in consultation with that relevant public authority, which is either a deemed control or processor, and along with the relevant regulatory authorities, classifies categories of data that may be permitted to be processed in a third country prescribed pursuant to an adequacy decision. What constitutes an adequacy decision has been specified in Section 26(2) paragraph A to mean a country that would be having equivalent legal standards and enforcement mechanisms relevant to protection of personal data. And based on the application and of a review of the application of some of the provisions, the key provisions such as Part 1, Part 2, and some of the key provisions contained in Part 3 of this Act. Now, an adequacy decision that would be made in the future is based on a recommendation of the future Data Protection Authority, and that would not be static. It would be subject to periodic monitoring of the developments in that particular third country. And that should be done on a regular basis, like 2 years. And of course, can be revoked or amended by the authority or based on the recommendation or consultation of the authority. However, what has been done is to provide a further consideration or further option for controllers and processors which are not public authorities. And it has been very clearly stated that non-public authority controllers or processors could process personal data in a third country prescribed pursuant to an adequacy decision, or in a country where the controller processor ensures compliance based on the provisions contained or based on obligations that are imposed under the various provisions cited in subsection 3 of 26, and based on options where BCRs and contractual provisions similar to what Ralph mentioned can be effectively utilized. But what is really useful for companies, businesses, and the private sector entities to know is this important exception that is available for private sector entities, including for government-owned business undertakings, that notwithstanding whether or not there's an adequacy decision, or even if there is no arrangement that can be determined to be available by the authority as being binding and enforceable through contractual measures, there is a flexibility provided for a controller or processor other than a public authority to process personal data outside of Sri Lanka on the criteria specified in this particular slide. So the boxes in this slide are reflective of the various options that can be used. Either one of these options in the boxes can be a basis to justify a cross-border data flow or processing of personal data outside of Sri Lanka by a controller or processor other than a public authority. And we have outlined the options very clearly here. So we can see in conclusion, the options range from explicit consent to a scenario where a transfer is necessary for the performance of a contract or the implementation of any pre-contractual measures taken by the controller at the request of a data subject, or in a situation where the transfer is necessary for the establishment of or the exercise of a defense of a legal claim, or it's necessary for the reasons of public interest as defined in paragraph G of Schedule 1 of the Act, and such other situations that have been laid out in this slide. So in conclusion, what I have to say, ladies and gentlemen, is thanks to the expert views and opinions that we were able to get from international experts, as I mentioned earlier, we were able to provide very clear exceptions which are factored in section 26(5) of the Data Protection Act number 9 of 2022, which will be applicable to controllers or processors which are not public authorities. And that would include government-owned business undertakings and state-owned banks as well. So with that note, I think we can go in for a Q&A. I'll be delighted to answer any further questions if required from this point in time. Thank you very much.
Thank you, Rajendra, for that very thanks a lot for taking us through the provisions of Section 26 and the PDPA. Just to spur the conversation and to get and I invite the audience to put any questions they have on the Q&A. So my first question would be to Dr. Shah, who spoke extensively about the different instruments that has been put in place by the European Commission under the GDPR to enable cross-border data processing. And I'd like to raise this question as to what are your thoughts on the formulation of Section 26, which Jan spoke about under the Personal Data Protection Act. Given the more, how would you place the formulation of Section 26 in a context where more conservative approaches have been adopted in countries in the Asian region elsewhere? So what are your thoughts on that?
Yeah, thank you very much for that question. So it probably comes at no surprise that I believe that the way Section 26 is drafted, its content is very much commendable. I think it provides a modern and flexible regime for data transfers that balances in a very good way, I think, the interest of data protection on the one hand, and then the interests and needs for cross-border exchanges on the other hand, which of course are more and more important, not just for trade, but also for regulatory cooperation, for law enforcement cooperation. Jayanta mentioned the second additional protocol, where there's also a dedicated data protection article. So I think if you mean with more conservative approaches, and I'm not quite sure I see them really everywhere in the Asian region, but if you mean with that much more limited or restricted grounds for data transfers, limited instruments, I think compared to that, the Sri Lankan law, Section 26, provides much more flexibility to business operators to choose from different tools. I mean, I understand that certain of them still need to be implemented, perhaps, but there are adequacy findings, which can be a very useful tool to really facilitate the exchange with certain countries. And then there can be, under the heading of appropriate safeguards, all these other tools that I refer to also in my presentation, and which can be extremely useful and can be easy to handle if they're designed properly, such as model data protection contracts. And as I said, there is a trend here. This is not just something which you find, I don't know, far away in the European Union, but it's something which you find also in the region. I was referring to the model data protection contracts, the model of contractual clauses developed by ASEAN. I think they are still at a relatively low level or lower level of protection. I think there is still a need to, over time, strengthen them. But that's owed to the fact that the ASEAN region has a lot of variety in terms of its membership and the level of data protection that you find in these countries. So it's understandable, and I think it's a very good first step. But it shows that more and more countries have an interest in that. And also, if you then look at countries like Japan, like Korea, and I think Taiwan is going in the same direction, and I also believe Thailand. So there are a number of countries that are also going rather in a direction that Sri Lanka has chosen to go. On the other hand, yes, I see a country, for instance, like India, that has just recently published a new version of their data protection bill, which only has one transfer instrument, which is adequacy, and it's not very clear actually under which conditions that would be granted. I don't believe that this is the way forward. It will actually make it very difficult. Either it's a serious instrument, then it will make it very difficult to transfer data to many countries, because it will take time to put these adequacy findings in place, or it will be purely political, and then there will simply be no assurance that data will be protected when it is transferred cross-border. And this protection is important for trust, also trust of consumers, to give a company his or her data. Individuals are concerned about where their data goes and how it will be protected. And if you can offer instruments that ensure this protection and at the same time give some flexibility to companies, I think that's the best of these two worlds. And both of it will help actually companies, because trust is more and more a competitive advantage also for business operators.
Thank you, Dr. Sa. I think that was a very valid point to make. And I think even when we, at the drafting process, one of the things we looked at about that approach that India, our neighbor, took back then in 2019. And I think in addition to, if I may follow up on the same question to Jayant, that there is certainly you did mention that there is a conditional localization requirement, which is built into Section 26. So do you think that this may potentially create barriers for public authorities to engage in, free flow of information, or will this put public authorities in a disadvantageous position in any way? What are your thoughts?
Yeah, thank you very much, Sadhuni, for that question. How I look at the current formulation of 26 in relation to public authorities is that we have a layered approach. So whilst we recognize that the public authorities would have a justification, in fact, many public authorities were not comfortable during the various consultative processes we had to go out of the localization kind of a mindset that was prevalent during the public consultation process. So while we have provided the mechanism to justify localization, we have not made it a mandatory obligation, because the current formulation of 26 is worded in such a way that provides a way out. The way out option is enabled through a future regulator working in consultation with the relevant public authority and guiding them on data classification and categorization aspects. And based on that model or the approach, the regulator or the future DP authority makes a recommendation to the executive branch of government to prescribe the adequacy decision, specifying third countries that have similar or equivalent legal standards to locate data outside the country. So in that kind of scenario, there is no mandatory obligation. And how I would respond to your question is that we have provided for options for even public authorities to consider. And looking at the current provisions, I would encourage public authorities who may be in this forum to begin that internal review process, identify the categories of data that can be located outside the country, so that when the new regulator is established, the dialogue can proceed with the next steps. My second point is, Sadhuni, why I say that this provision does not create a disadvantage is that unlike in the previous versions of the drafts that we had, including up to the bill version that was gazetted on the 25th of November 2021, we have moved on to create some degree of public flexibility for public authorities doing business operations. So government-owned business undertakings, public corporations, including state banks, are exempted from the new definition of a public authority, and therefore government-owned companies and entities like that would have greater flexibility to use the same standards similar to private companies in relation to cross-border data flows. Right. So therefore, there is no disadvantage for government-owned business undertakings, public corporations, state banks. They are on the same footing as private sector entities when it comes to looking at options to host data outside the country. Let's be very clear on that.
Thanks, Jan. Thank you for that explanation. So there was a question I'd like to take at this point on the Q&A, which sort of relates to cross-border and also towards, I suppose, in a way, to consent as well. So if I may put this question to both Jonathan and Dr. Saar, can an organization reject servicing customers who are who does not allow to use or who does not allow storing data in the cloud? And is that a violation under the PDPA? So I think essentially the meaning is, can you refuse to serve a customer who says no, who does not provide his consent to store his data on a cloud platform as a control?
Yeah, so if I'm to go first on that, maybe Ralph can add to this. Consent is only one of the options. There are multiple other options available, as we pointed out during the slide presentation I did earlier. If a provider can justify the transfer for the purpose of performance of a contract, then that would be another option available, right? So consent is only one option. And it may be interesting to hear what Ralph may have to say, a situation where a customer has withdrawn consent. In a situation like that, whether a controller or processor can still justify a transfer, well, on other grounds like establishing a legal claim or a legal defense or whatever.
Yeah, I mean, I can of course only answer to this sort of from an EU perspective as how we would deal with this. I cannot answer it for the Sri Lankan data protection law. We make a distinction, and I think that's the same in the Sri Lankan law. We make a distinction between what we call grounds for processing and then grounds for data transfers, or the first one we might also call the legal basis for processing. And consent appears in both of these areas. So there's, first of all, I guess, a question on which basis the data is in general being processed. If that's done on the basis of consent, and if consent is withdrawn, then simply never mind the transfer, you would simply no longer be able to process the data unless there would be an alternative ground on which you could rely. And then for data transfers, indeed, consent is only one of the grounds for transferring data. There might be other statutory grounds, and Jayanta has mentioned, for instance, performance of a contract. Of course, not everything is necessary for the performance of a contract. One can probably have a debate on whether the storage in the cloud is necessary to perform the contract, but it might be in certain situations. If the company itself is not able to store the amount of data it has, I don't know, it depends on the circumstances. But then there might also be appropriate safeguards instruments, for instance, that if the company that has my data would be able to conclude a contract based on model data protection clauses with the cloud provider, then that could also be a way to transfer the data, and it would not depend on the individual's consent. Again, as a ground for transfer, there might be, I mean, a transfer is a form of processing. So to the extent you need a general basis to process the data, if that's consent, then it might fall because of that. But in principle, there are different ways to transfer data, and consent is not the only one.
Thank you for the clarification, Aksar. So I'd like to raise this question, which was raised during the earlier session as well, about the concept of doing transfer impact assessments. So at what point should, I think this is more of a European concept at this point, but how should one go about doing a TIA? Or, I mean, is it a TIA essential if you are going to use SCCs or other tools for transferring purposes?
Yeah, so this is indeed something which a couple of years ago one would not have thought about, probably. In an EU context, this has come about with a judgment from our highest court, the Court of Justice, which looked at it from the perspective of the general principles that I described in my presentation, namely that we're talking about a fundamental right, that the protections that should be afforded should not stop at the border, but there should be continuity of protection. And then develop this one step further to say, well, therefore you not only have to address the risks that stem from the actions of commercial operators, so the data importer, the way it treats the data, but there might also be risks that come from access by public authorities in the third country to the data. Not as such, because of course government access is something which is quite normal. For many reasons, governments, public authorities need to collect data, access data, use data for very legitimate public interest reasons, but it's about abusive or disproportionate government access. So that's sometimes overlooked in this whole debate, but it's very important that, of course, our court did not in general sort of criticize government access, but just said that there has to be some kind of assessment whether there could be disproportionate abusive government access. And frankly, this is, I mean, as we see now, this is not just a concern in the EU. We actually see more and more countries around the world that share these concerns, in particular with respect to authoritarian regimes. Just refer you to yesterday's declaration on government access that the OECD ministerial, which is taking place right now, has adopted. And there's a reason why this declaration was developed within the OECD. So I think we have currently more than 30 countries that have developed this, because there is a general feeling that disproportionate or abusive government access negatively affects trust, and therefore can actually become a barrier to data transfers, simply because customers, individuals are worried where their data goes because of that. And that was the trigger why at the OECD, which is typically not looking into matters of law enforcement or national security, did so because of this link to data flows. So there is something which is more and more, I think, on people's mind. And of course, carrying out these data or these transfer impact assessments is certainly not something which companies like, and I can totally understand that. And it's also not necessarily an easy task. Although one should also bear in mind that it should be a transfer specific assessment. So we're not talking about a mini adequacy finding that a company has to carry out, but a company should, at least according to our rules, look into whether the specific type of transfer and in the context of which the data is transferred and with respect to the specific recipient, whether there are risks of disproportionate government access. And that's certainly, these risks are higher for certain types of data, like communication data, than it is for other type of data. We are still grappling a bit with the consequences of this judgment. It is certainly now something that data exporters in the EU, because they have the prime responsibility for that, need to do. And that's and I think some trade associations are starting to build up expertise and knowledge on this to support their membership. And I think that's one good way to go about it. Our data protection authorities have commissioned certain studies for certain countries to also support these efforts. And then we try to help, of course, with, for instance, adequacy findings, where we, in a way, carry out, I mean, not in a way, where we carry out this assessment. If you remember my slide, there is also this part of government access that we need to look at. That's one other reason why an adequacy finding is particularly useful, because then companies no longer need to worry about this. So all of this to say, it is now a reality, and I think more and more countries are doing the same, because you also see this in other instruments. For instance, the model clauses developed by New Zealand, or the model clauses developed by the Ibero-American network, they all have rules on government access and the need to assess that. So it is a fact. We need to find ways to support companies in this exercise, and of course, we need to work on ways to maybe also give reassurance, and the OECD declaration is one important element of that, because it shows sort of what are shared basic principles for government access, and I think that it is sort of that kind of reassurance that we are looking for with respect to countries that data is going to.
Thank you, Dr. Sa. That was a very, I think that cleared a lot of doubts. Even I personally had, the intersection between TIAs and so on. I'd like to direct the next question to Jan, of course, because You don't find this sort of language in Section 26 at this point of time. So because Section 26 leaves room for the Data Protection Authority to specify certain instruments like the CCs or PCRs or TIAs for that matter, to enable data transfers to recipients located in countries which does not have an adequacy decision given by the Data Protection Authority in the future. So can you perhaps enlighten the audience as to the potential nature of these instruments and what controllers and processors may adopt in the meantime until such time the DPA, the Data Protection Authority, prescribes the relevant instruments and tools?
Thank you, Sandhuni. That's actually not an easy question to answer, given the fact that I am bound to say this actually at many fora when people ask me questions, possibly that would we have to be dealt with by the future regulator. My standard answer is that I am not able to predict the future that much, and I will not know how the future Data Protection Authority would determine certain aspects, and I would not have control over the future decision making of the Data Protection Authority, which is yet to be established. But that said, in order to guide controllers and processors who may have to look at options relating to instruments, it's important to look at the Data Protection Act not in isolation, but as a enabling instrument. And I keep reiterating this in number of fora, that one would have to look at this act in the context of the preamble. And if one were to look at the preamble to the act, it is stated explicitly that this law was done to facilitate growth and innovation in the digital economy. And it goes on to further say that this act is done in the context of improving interoperability amongst personal data protection frameworks and to strengthen cross-border cooperation amongst enforcement authorities. I just want to flag these last two and reiterate the fact that whatever the nature of the future regulator would be, they would have to take cognizance of the fact that there needs to be interoperability between ours and the international development of this subject area to ensure interoperability, so that the future regulator will be able to strengthen cooperation with other enforcement authorities. In that context, how I would answer your question is to conclude by saying it's imperative that we enter into dialogues, or we persuade the government authorities responsible for the setting up of the Data Protection Authority to enter into discussions with international, more mature enforcement authorities, some of whom are represented here, including our colleagues from the European Commission, so that in the formulation of even the instruments, we don't try to reinvent the wheel. And today we heard from Dr. Ralph options available, including the standard contract clauses and the BCRs, the binding corporate rules that have been adopted from time to time. So why not encourage possible controllers and processors to look at models like that and replicate similar options in our territory, so that the fundamental principles and the philosophy behind the Act, as articulated in the preamble, can be perpetuated, so as to create an ecosystem where we don't act in isolation, but work collaboratively with the rest of the world, taking note of the fact also that for Sri Lanka, it's important to realize that European Union is the second largest export market. So I just would like to highlight my response in that context. I don't know whether I gave a very clear answer, but I want to give an answer, not being able to predict how the future regulator will behave, by concluding by saying we have to look at the fundamental philosophy behind the Act and engage in collaboration sooner than later with more mature entities, and also engage with other more mature and advanced regulators like the one we have in Singapore and maybe Korea and Japan, to see that the principles, as I articulated before, would be ensured in the future. Thank you.
Thank you, Jan. Thanks, Jan. Just one quick question to both Jan and Dr. Sa in this regard, just for a very brief intervention. So, do you think the current formulation of Section 26 on cross-border processing in the PDPA has the potential to enhance onward and outward cross-border data processing in Sri Lanka, given the BPO and growing BPO and BPM and tech service industry in the country? Have a very quick response to that, if you may.
From who shall go first?
Yes, please.
I think probably Gerd is much better placed in answering this. From my side, I would give a clear yes answer to that. I think I've already said a lot about how I see the outward direction. I believe it's up to sort of the most modern data protection regimes that we see out there. What you have in Sri Lanka, a flexible toolbox that will inspire confidence of consumers, and I think that's, as I said, very important to attract business and then to cooperate with others. As regards the inward direction, I think it's less Section 26 that will be relevant. It's rather that also the rest of the Personal Data Protection Act is excellent, and I think it ensures a high level of data protection, and I think that's what will be important for other jurisdictions to consider, whether data can go to Sri Lanka and be processed there. Now there is a strong statutory framework for that processing, and I think that will have a very positive impact as regards data flows to Sri Lanka. And again, if I make the comparison to India, in the current bill, there is a kind of a carve out for incoming data, an exemption. I think this is a very bad idea, so I think, and also the law is by no means as strong as the Sri Lankan one. So I think you're in a very good position with law as it is.
Thank you, Dr. Sao, for that note
So,
of confidence.
yeah, that's thank you very much, Sandhuri, and thank you, Ralph, for that excellent answer. So I would simply say yes, and also say and go to the extent of saying that opening up our drafting processes to discussion with international experts across borders has ensured that we provide options, and there is greater flexibility for businesses to consider in view of the provisions that we have explained already. So I will simply say that I agree with Ralph, and thank you very much, Ralph, for joining us this evening.
Thanks to
Thank you.
both of you, and it was as always a pleasure. And the good thing is we will all stay in touch because we have established a dialogue with Sri Lanka, and we want to continue on that path. So thank you very much for the invitation.
Thank you so much, Dr. Sa. So that actually brings us, unfortunately, to the end of today's workshops, today's second session. And I'd like to thank Dr. Rausa, who is Deputy Head of Unit International Data Flows and Protection of the European Commission, for joining us amidst his very busy schedule today and sharing his valuable thoughts on cross-border data flows in Europe and beyond. And also to Jayanta, who is our General Counsel at ICTA and Chair of the Data Protection Drafting Committee, for taking time off to speak about the local perspectives. And with that, I'll hand over to Shiran from the Ceylon Chamber of Commerce. Thank you, everyone.
Thank you, Sandhini, and thanks for putting together this session. I think it was our fourth workshop in this series together with ICT and Meta. And I'd like to, on behalf of the Chamber, thank the speakers who joined in for both parts of the workshop. Dr. Ralph, Jayanta, of course, we've been long working with on this, as well as other advocacy efforts. Darren, Lankesha, Mohan, and of course Sandhini for moderating and guiding this process. So this, I think we could conclude this year with this workshop related to personal data protection, and I think there is more to be done in terms of the advocacy and the preparedness of the private sector, and we look forward to developing programs like this so that the private sector will be ready when the implementation process really starts off. So let me once again thank Sandhini for putting together the team at the Chamber, as well as Jayanta Fernando for his constant guidance and execution of this, and our speakers across the series for joining in as well. So thank you so much. Have yourself a good rest of the day and a good evening, and season's greetings as well. Thank you.